हाँ कोटा कोटा हाँ अच्छा सर पसंद है ओके हाँ ओके ओके प्रोडक्ट्स ओपन करिए
सर ऐसे ही दिखाएं।
कोटा लॉक लॉक मीटिंग ఉంది ఆన్ చేయాలా ఆన్ చేసా నేను సెట్ చేస్తున్నా ఇట్లా కూర్చున్నారు కదా లాక్ చేసిన లాక్ చేసిన టైమింగ్ 3 to 7 4 hours yes ఓకే 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 పంపిస్తాను
Introductory fighting agreement in 5 minutes. The justice question speaking, the right to the photo please last me. Good times to you interpreting factors in the last year to other things. Okay. So justice question speaking, then the evidence is that then Mr. Ravikant, then Ekta Will, then Chitra around, we decided just to keep and then after that results started acting and then we went to procedure. We have the wine stance. Started with the bit in this company, this year was he was younger lady
Water. उनको चाहिए एक
Is it?
participant, mediator.
Tell them to fill it from our field.
They don't have water.
Sorry. Okay. What I do, I'll put the Nalsar super and put a smaller stopwatch which will keep on going. Like a small one, so like a large one, so that you can see that thing. Because if the NP thing is white in color, we can write it. So okay. Okay. We will not put in the paper.
एलएलबी जोधपुर वो एसपीसी के पास खुद
क्या क्या क्या
रिस्पॉन्डिंग पार्टी
Where are they? बुला दो हाँ बुला दो.
वो एसपीसी के पास खुद
Why call them?
आई डोंट हैव टू नो
Number no, who called them from there? Have you sorted your 15 minutes left, 75 minutes?
yeah
Both the sides?
with the sites.
Okay. 75, 30, 15, 5. 1. Okay. We'll also be displaying it here. So
Okay.
that you might be.
But how will display it here because वहाँ पे उनका वो चल रहा होगा ना स्क्रीन पे मीडिएटर्स अपना वो लिखेंगे सर।
नहीं वो लिख नहीं रहे,
क्यों
दे इट्स देयर चॉइस।
नहीं लिख रहे? श्योर पूछा?
हाँ he came and told me.
नाइस।
हेलो। हाँ। ओके। ओके मैम। ओके मैम। ओके। हाँ हाँ अच्छा ठीक है। ओके। काफ़ी बढ़िया। हाँ ओके, हाँ ओके। हाँ हम सुने थे। हाँ हाँ चेक सुना वो सर चेक। हेलो चेक हेलो। अब एक बार है ना वो मेल में भेजा था।
सेटिंग बोथ साइड।
हम रावట్లేదు हेलो चेक हेलो। आवाज आ रहा? डबल लाइन पर।
ऐसा होता है कभी? अच्छा
हाँ
स्टार्ट नहीं हुआ है क्योंकि तो 10-15 मिनट में, 10
कर
मिनट में
करके
या
रख
अभी
देंगे।
कर दीजिए वरना कर।
हाँ చేయమంటుంది
अन्ना मुझे यहाँ पर माइक
हेलो चेक हेलो।
इसको देना है ये। दोनों बैंक।
अटक जाएगा थोड़ा सा।
हाँ कर देगा।
हाँ सही है। टाइमर मतलब स्टॉप हो जाए। लैब भी करना पड़ेगा बीच में क्योंकि वो भी होगा क्या कॉकस है। कॉकस में लैब टाइम लिमिट होती है ना कॉकस की 9 मिनट टाइम
फोकस में
लिमिट
9 मिनट का टाइम।
टाइम तो होता है।
इतना मैं तो 9 महीने लेकिन इतना तो आता है ना कितना टाइम निकल गया है 9 महीने
एग्जैक्ट
नहीं।
निकालने में क्या दिक्कत है?
बताना पड़ेगा।
एग्जैक्टली देखिए, जब 9 मिनट में जैसे 4 मिनट होगी तो 5 मिनट का फिर वेव करना है।
हेलो चेक, हेलो। आ रहा है आवाज? Hello, check. Hello, hello. Hello, hello, check. Hello, hello, check. Hello, hello.
Hello. तो uncomfortable ही हो जाएगा. Hello.
Are we audible?
Hello.
So we'll not necessarily have to pick it up, no? I mean, if we speak like this, we're audible, or is it better if I speak like this?
Hello.
Alright. Yeah, okay, fair enough.
Are we audible?
You'll have to be louder. I think we'll be fine.
I can't be louder. Hello.
If you want to pick it up, you can always pick it up. Just be audible.
Hello.
ठीक है.
Hello. I don't.
मुझे realize नहीं हो रहा.
See, when we're speaking, I
Yeah,
think
please. हाँ, can you go behind? मेरे को भी लग रहा है. पर पीछे चले आके बताओ. You can speak something. I don't think so. We are audible.
say good afternoon.
Good afternoon. पता चला ना पीछे आ जाओ. Let him go.
पता कैसे?
Good afternoon to the judges.
But the thing is, you'll not be speaking
Hello.
like this.
Right. That's not on.
Hello.
भाई माइक से नहीं मुझे लग रहा वैसे ही.
पता नहीं बस.
अरे सुनो.
Hello. Hello. Hello.
देख के तू.
Hello. Hello.
Hello. Hello. Hello.
Hello.
So I'll have to pick it up, or am I audible like this itself?
I think you're audible.
Audible. Okay, so if I speak like this, I'm audible.
Yeah, I think you're audible.
But
Hello.
this is louder.
ठीक है यार कोई बात नहीं.
Just keep it like this.
Hello. Hello.
Yeah. Am I audible?
Hello. Hello.
Wouldn't it be a little uncomfortable to go to and fro?
Hello.
Hello. That's fine.
Hello. Hello.
No.
तो वो very close ना उसके लिए.
I'll speak it like that. So
ऐसे थोड़ी बोलेंगे. Hello.
yes, write it down. Very close.
Hello. Hello.
इसी में लिख लेंगे.
Says only for hello. It's like writing.
Hello. 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 Hallelujah.
Again, are we audible? All right.
Hello. Hello.
Hello.
Agi will be loud. Okay.
Yeah.
इसको send.
वो अपना नाम से बोल के रखे रहते हैं.
हाँ चल रहा है.
Hello, check.
discussion.
Hello.
Like we're up. Our table is a bit removed from that party.
I think it's just because you're sitting here that you feel better.
No problem.
Hello, check. Hello.
Where is it? Should sit there because it's not a nice look.
All right.
Having pockets. Okay. Put in a
I think the silent.
Hello. Hi, a very good afternoon, everyone, for uh, the final rounds of the third edition of Nalsar Mediation Tournament. We wish a very warm welcome to all our esteemed judges. We thank them for taking out time from their busy schedule and gracing this occasion. We also want to congratulate all the teams which have made so far. We want to congratulate the mediators for making so far. and we hope that we have a good round today. Uh, Thank you so much, Chitra ma'am, for taking out time from your schedule. Thank you so much, Ekta Bahel ma'am. Thank you so much, ML Joseph sir. Thank you so much, Anirban sir. Thank you so much, Tariq sir, for coming down to our campus. Thank you so much to all of you. I hope we put a good show today. As we have already shared with the teams, it will be a 1 hour, 30 minutes round. We also have put up the timer on the screen so that it's easily accessible for all the teams. We have Mukul with us, who will be keeping a tab of the time. And after every few minutes, he will be showing a placard to ensure that the teams are aware of the time that they have already spent. We also have Vinay on the other side, who will also help the teams to keep a tab of the time. With that, I'll not take much of your time. All the best. May the best team win. Thank you so much. Please start.
Good afternoon to the divine beings of Olympus. I want to thank you all, first of all, for coming down here on a Sunday afternoon. I hope you're all comfortable, that the journey was nice. All right. Please let us know if you need something from us throughout the competition, throughout this session, sorry. All right. So why don't I begin by myself? My name is who may refer to me as Lizzie. I prefer general. So why don't we put few minutes, like, also give us something.
Definitely. Hello, everyone. I am Zeus, god of sky and thunder and ruler of the gods. You could please refer to me as Zeus, and my preferred pronouns are he and him.
Greetings, everyone. I am Percy Jackson, son of Poseidon, a demigod. Today, I am here as counsel for Lord Zeus, and my preferred pronouns are he, him.
A very warm evening to everyone present here. My name is Hephaestus, and you can refer to me as Hephaestus during the course of the session. And my preferred pronouns are he and him.
A very good evening to everyone present in this sacred gathering. My name is Ambrose, and I'm Hephaestus's trusted advisor and his legal counsel for the course of today's sacred gathering. Thank you. And my preferred pronouns are she and her.
Once again, I just want to clarify what you said.
Yes, I have the authority to say.
So, just want to bring back the memory of you understand that G on the table is not easy. Coming to this point, I do one of the issues that also valuable for everyone. But the fact that you're here shows your willingness and your dedication towards following values. Now, since you're all gods and demigods, the way I'm discussion today is the way we get conquests. Sorry, quests to think about the most fighting. So, when you open a quest, you will be faced with orders that are small, and they will be worked as biggest many laws in the case. Ultimately, choose that take parts that are true, that will be your desires. So I hope that through today's session, if all the better embark on a journey of conflict resolution. And we hope that going into the future, we can find potential get out of the solution. So I just like to tell us what we can expect.
All right, and it's in the book and it's Let's bring it sharp. Let's take it step. Post. Understand it. Post. Sense it. Post. Everything is section. You may see how it has this issue because people's current testing has been. I hope the first school, but we could do the points for
Yeah.
or they that someone say what it is essentially the part. What will this also the finance like it became analysis of proportions. But we will finance it's the challenge. It's okay. So that I will count validation. And I answer it with learning. Just possibility. Okay, good. Partiality is subjective measure. And it means that and if you judge all the practice, you also have when last by each upgrade on switch. Any second, if any, that outside of this session, check out the site. Come on, in any then find out all things. As I Google, you can go out. You will press. And in this test, the prediction are lying. Completely lack as a doctor's of all, but I'm writing all the possible prediction. I know your remarks. Also, next step. I think this seems important. All of us. We are just but the trick I understand is
now I understand that parties regarding what visitor or patients within that. Just that. Going over what we expect. So this is a 90-minute session, and as it's visible, it's done with other statements that what to expect, and then we can move forward with this lot of these statements. Where please feel that is no silence for me, and I encourage both parties that is the interest aspirations from these patients. Now, once we establish those interests, we will try to find common ground and both parties in their definition. Once we have once we break it down towards discussion, I encourage both parties to then start exploring each other's discussion, and they can go ahead and be very open about what they want to talk about, why they do. Now that
Finish.
I don't get where both of you might feel like we have a private session with us, or what we call a box. So you can always follow the box, or that this discussion is not with us, and people will be following the box. Now this private session will last for 9 minutes for each part. We also understand that in such situations, it's where it's thinking of. So everything that you need to know, then sit down and have a discussion with your parent. We also have the function of the day. On this day, there will be 6 minutes of each one. Understood? However, if you want to go, then you have 7 other points. Now, established. There will be a moment where you might come to settlement. If you come to a settlement, then we will be signing mediation settlement. However, this will be a longer. It always. Now, so I have mediated like so long. We just think that it's good to have for mediation because we feel that it makes for a very good discussion. Now, these are the things that I wrote very well. First, please feel I the first is I understand that where gods and goddesses and demigods therefore please trying to respect each other and also in the meantime try to respect the process. Don't use harsh and abrasive words, try to be calm and collected. Even if it's difficult, always have to be how we opportunity to talk once down. Second, if have anything bad, that's otherwise we will be waiting.
Right.
So I what I do in defense, the leader might can give you. They have because the teams have it, the mediators they can.
Yeah, is it better?
Okay.
Yeah. Is this better? All right. Adding to what my co-mediator has so successfully put out, right? There are various stages to the mediation process, and I want you to let you. I just wanted to let you know that this process, if you do not like remember any of the stages, it's all okay. This is a client-centered process. Moreover, this is a flexible process, so we can accommodate to your demands. And I hope that this courtesy is not only limited to the process itself. Anything that the parties need for them to be more comfortable, we'll be able to do that. And moving to the council, yeah.
Right. So I just had to ask for a small clarification. Lizzie, like you mentioned that before we go into a joint session, we'll be setting the agenda. I just wanted to know how will the agenda set in such a manner that it is not prejudicial to either the interests of Zeus or to interests of Hephaestus, and whether we will be following a flexible approach when it comes to the structure of the agenda.
Certainly, that's a very important clarification. Thank you so much for asking. So we do encourage flexible process when it comes to setting up the agenda. So if both the parties feel the need to have found a common ground and discuss it in terms of priority, that is a thumbs up from our side. But if you ever feel like you are a little confused and you require our help, we will also try to present a common ground if we find the need, and we can always suggest changes. Does that answer your question?
That does. Thank you so much.
Okay, thank you so much. So why don't we begin with the request?
Thank you so much. Firstly, I would like to appreciate both Aristus and the mediators for very nicely elaborating as to what the mediation would entail. I was a little skeptical before because this is not how we solve disputes in our realm. But I'm quite confident now that we know what the ground rules are. And I'm quite confident and hopeful that we'll be able to find a way. So my name is Zeus. I'm the god of sky and thunder. Firstly, this is one thing that I usually say, that peace cannot be built by force. We need mutual understanding for that. So in furtherance of that, I, amongst all the equals of Olympians, had brought an idea of establishing a conclave that has been running for the past 2 days in order to solve the dispute that is brought in front of us, to determine what the ideal rules of interaction and engagement with the mortal realm and one another must be, both in the mortal realm and our Olympic. So for the past 2 days, I've been following the discussion and
things have not gone quite as I expected. I thought that, over the discussion, we would have found a middle ground, but the disputes just kept on getting rising. But as a common saying in the hymn, for the lips of Zeus do not know how to lie, but bring to fulfillment every word. So I shall wholeheartedly work towards devising a system and set of rules for interaction and engagement with the mortal man. So, as has been explained by the mediators, one aspect of mediation is that all parties need to wholeheartedly, be open about their issues and what their agendas are. So, if I am being honest, I'll explain my agenda in one simple line. The idea of conflict of laws now makes me more and more uneasy, and it feels like a devolution of power of the sovereignty. So what I look forward through this mediation session is that we come together, join our hands, and find a way, find a system of laws that is both beneficial to us and to the mortal lives. Over to you.
Right. First off, I would like to thank everyone present here, especially Sisyphus and his council. Thank you for accepting our request for this mediation and taking out the time from your cosmic duties. And for the mediators, I'm really impressed the way you explained the whole process. I don't think I could have explained it better. And now, before I start, I would really like all of us to really soak in this moment. We are sitting in a conclave which happens probably once in a millennia. For eons, it won't happen again. And we have this opportunity where we can understand each other. And I believe that understanding is the first step to resolving any dispute. Now, I would like to clarify my position today here. So, as I explained, I am the counsel for Lord Zeus, and what it entails is basically I will be assisting him in presenting his concerns on this table today, and further, I will be helping him with any technicalities that might arise during that session. Furthermore, I would also like to mention here, and I think my peer on the other side will agree with me on this point, that mediation here is going to help us a lot because the kind of disputes that we are being presented with, these are not normal disputes, and especially since these disputes have impact throughout the realms, throughout the fabric of space and time itself. So I feel that this method that has been devised by mortals, if I may say, I am very impressed with it because it allows us to go into the heart of the matter, to understand what the other party's aspirations are, what they really want, and probably find a middle ground or an alternate than what we came up with. So with that said, should I put up my agenda for the day? Right. So the agenda from Lord Zeus' side for the day, as he explained very eloquently, is basically we would like to reach an agreement on how to regulate the dealings between individual gods and the mortals.
Thank you, Zeus and Percy, for laying out your agenda in such a concise and transparent manner. If I am to recap what all you have said, and please add if I miss something. So Lord Zeus says that the motive for organizing this conclave was to determine the rules of engagement with mortals and in between the immortals through a process of mutual understanding. Therefore, the agenda for Zeus today is in pursuance of the same, and your concern is that you want to reach an agreement on the rules of interaction between gods and mortals. Would that be correct?
Gods and mortals, and between individual gods as well.
All right, so two agendas related. The determination of rules of engagement between gods and immortals and between gods and mortals. Would that be all?
Exactly. So basically that entails the choice of law. And I believe that it is better if we have two different agendas. You are right about that. It's better if we have two agendas, that is in regards to the individual gods and the god and mortals.
All right. I believe now we can move to Sisyphus and Amber, and they can explain their side of story and perspective.
A very warm evening to everyone present here. My name is Hephaestus, and firstly, at the outset, I would like to thank Alex and Lizzie for explaining the process so wonderfully. Like before coming to this session, I was talking to Ambrose as to how like this sacred conclave being called by Zeus itself is going on, and different gods are coming and engaging and delving upon the issues of the immortal realm. I was talking as to how these things happen, but the way you have explained to me, I'm really happy, and I think that I have a very clear framework as to how next 80, 70 minutes would look like. Thank you so much for that. Coming to you, Zeus. I'm really happy that you've invited me here. And also to the fact that your invitation means a lot to me. You talked about the fact that you want to talk about the ideal rules of engagement. I think that this is something which we have in common. I think that we also want to have a position where we can talk about all this in a very free environment. Now, as Homer said, that even the gods have to come at the time of uncertainty, at the time of necessity. Here we are. And I'm really open to everything which you propose, you being the god of all the protectors of the mortals, you being the supreme god. I'm very open to hear whatever you want to say here. I am here along with Ambrose, and Ambrose has been a long aid and advisor for me. He has been there for my assistance since time immemorial. And despite having a sore throat, Ambrose, you can have water whenever you want. She is there for my assistance. Now coming to your points, Zeus, and making my position, I'll make my position understand in a better manner. My basic position is that Ambrose, you called for the sacred conclave because various incidents which happened in the mortal realm, and because of the divine intervention into the mortal realm. It was related to the actions of Apollo, the COVID pandemic which was caused, the Hermes incident in the Suez Canal, and all those incidents. And this is a very fair thing which we decide at this juncture. We have to decide that where does lie the interference part. Where does there exist substantial interference and where does not exist the substantial interference? And I'm very in with that concept. Now, Zeus, I also want to talk about one more major aspect. During the course of the conclave, we had sessions between Hades and Charon. We had sessions between Ares and Hermes. We had sessions between Aphrodite and Athena. And during the course of these sessions, we had one thing in common. That one thing in common was with regards to the conflict of law provisions. And by conflict of law provision, as you also talked about, that what should be the applicable law when there is no choice available to the parties. This is something which we need to consider at this moment. Aphrodite, we have history regarding Aphrodite, how Hera, your wife, told me to create her, and she gave a very beautiful suggestion with regards to this in the previous conclave, that there can be different moments when the choice of law, with what you talked about, there does not exist any choice of law. You and me, being a party, we are choosing what law we want to make applicable. However, we are not able to decide. In that situation, what type of law needs to be applicable? And in such conflict of law provisions, we need to have some mechanism in place. So I think for me, the primary concern would be to establish some sort of a conflict of law provision and how it has to work in the immortal realm. And besides that, Zeus, I'm very happy and I'll be very open to whatever you want to suggest with regards to your idea of choice of law and with regards to your idea of interference between the gods and mortals. I think Ambrose will be in better position to highlight the points of discussion which I want to have today.
Thank you so much, Hephaestus, for such a clear articulation of the concerns at hand. A very good evening to one and all present in today's sacred gathering. My name is Ambrose, and I'm Hephaestus's trusted advisor as well as his legal representative in today's sacred gathering. First of all, I would like to thank Lizzie and Alex for their comprehensive elucidation of the mediation process. Your explanation has definitely put us at ease and has also instilled more confidence in our hearts regarding the process today. I would also like to thank Percy and Zeus for inviting us to this session and for your commitment to this session, as your presence here is vital in order to have any sort of a meaningful dialogue. Having said so, today we have come here to deliberate upon the rules of engagement, not only between individual gods, but also between the immortal realm and the mortal realm. Having said so, like we have seen in past conclaves, there has been quite a lot of commitment and efforts that have been put by other various gods in order to arrive at a uniform system that will guide the interactions between individual gods and provide some sort of certainty and predictability that we currently lack. Now, I have known him for what seems like an eternity now, and having participated alongside him in various great conclaves before, I can say with unwavering confidence that his decisions are not only guided by a sense of level-headedness and prudence, but also by a remarkable sense of pragmatism. And therefore, we hope that today we all can collaborate and show commitment towards a harmonious existence. Having said so, I would also like to clarify my role in today's sacred gathering. I'm here simply in a representative advisory capacity. And while the situation at hand is a legislative problem, I will be refraining from using complex legal jargons and immersing our discourse in a whirlwind of legal jargons. However, should the need arise for me to use certain legalese, I will try my best to explain it in the simplest way possible in order to avoid any sort of confusion. And after a very thoughtful consultation, our main point of discussion for today's session will be to set a conflict of law provisions, wherein we would like to concentrate on three major aspects. The first one being to discuss how conflict of law provision can act as a gap-filling mechanism. Second, to discuss the formation of a conflict resolution mechanism. And third, to discuss regarding the formation of a divine legal code. I hope that today's deliberations will be guided by the wisdom of Athena and the fairness of Themis and a collective goal of harmonious coexistence in the cosmic order. Thank you.
All right. I believe that since both of these just have been forward, I would just like to clarify once more what the agenda points number 1 and point 2 were.
Right.
Because I believe that there is a certain I didn't quite hear it right. So if you could just say once more, clarify.
Right. So I've actually written down the agenda on a piece of paper for the clarity of both the parties.
We can pass.
Thank you so much. I think this makes your agenda point quite clear for everyone here.
You're welcome.
But before we see something as a common ground, we would like to ask both the parties to consider both the interests that has been put forth. And if you see some common ground that you would like to go ahead and set the agenda for discussion for, we are open to hearing that. And you can also say it in terms of your priority of agendas. If you require any help, please let us know.
Right. So I have a suggestion. What I believe is that we have a broader agenda of deciding the rules of interaction, choice of law provision, you could call it, in regards to what happens for disputes between individual gods as well as gods and mortals. Am I right here?
Right.
Right. So I believe that we can make two agendas, keep them broad. And what I see is that the conflict of law provision, the three-pronged agenda that was presented by Ambrose, can be seen as a rather one of the solutions that we can discuss under the agenda.
If I may add to what Percy has said, I believe the establishment of a conflict resolution mechanism, which is agenda second proposed by Ambrose, it's quite similar to what has been asked by Zeus and Percy about establishment of rules to regulate relationship inter se and intra se. So would it be correct to say that there's a congruence of intention here?
So when we talk about conflict resolution mechanism, this will be something that will be guiding interactions between individual gods. So we can take it under that agenda. Hephaestus, do you have any reservations regarding that?
I think Zeus, while deciding the rules of engagement, conflict of law provision would automatically come into the picture, so that we have somewhere in commonality and we can discuss it together. I think that this can be a common agenda for us, if it's fine with you, Zeus.
I absolutely agree. I think broader discussion on the conflict of law aspect would perhaps cover all the issues that we have.
Definitely,
Once we
definitely.
start, we can keep devising the subtopics and sub-agendas as we.
Certainly. So for the clarity of everyone here, just on the same page, we would start the conversation with the conflict of laws provision, and then we will be having sub-conversations about the potential solutions, for example, the conflict resolution board that is being talked about. Am I right in understanding?
I would like to bring a clarification here. So conflict of law provisions, conflict of law as a system is a solution for interaction of rules, right? So we create rules under that conflict of law and it becomes a system. So it may be there that we can come up with another kind of system. It's not necessary that we have to go to conflict of law system only. So for now, I believe that we should start a discussion on conflict of law because that is the only solution that we have on the table. But we should not restrict ourselves that that is the only system that could fill the gap for regulating the interaction between gods or gods and mortals.
So I think that since we have decided agenda number one, if both the parties agree, we will be talking about the conflict of laws as a topic first. Is that correct?
Yes.
Okay. So why don't we begin the discussion?
If I may.
Definitely, Zeus.
Before coming to the table, I had a preliminary concern that I'd also raised in my opening statement that setting up the idea of conflict of laws sort of we feel like it's a devolution of power of our sovereignty. Imagine the parties making rules. Where are we in that? Where are we in the picture? Where is our sovereignty? Where is our power to make rules? So it sort of goes against our sovereignty. So I would like to know what are your views on this aspect? Maybe you could tell me what you think could be devised as a way to, help keep up with our sovereignty.
Definitely, Zeus. I understand your concern. However, Zeus, with regards to the aspect that sovereignty will be affected just because there is no power to make rules, we are talking about the aspect that when there exists no law, we'll be the deciding authority as to what kind of guidance would be given. So the power rests with us. Zeus, if you could please clarify what the entire, like, where does you feel the reservation with regards to the problem of your power? Ambrose, if you have anything to add to this?
Right.
I think I can explain it for Lord Zeus here. So basically, if you were able to see the session of Hades, you would realize that there was a conflict between Hades and Sharon as to that what choice of law would be given. So essentially, Sharon was asking for party autonomy, if I'm not wrong. And in that sense, Hades felt that his sovereignty was being taken over because if he starts to give party autonomy to his servants and his minions, then essentially it will lead to a cascading effect and maybe a revolution in the future as well. And what that entails basically is that he already had a system. For example, he had a tribunal of the dead, and giving parties the power to choose the choice of law provision would have essentially created ruckus in the underworld and would have taken his powers away. So that is the kind of concern that Lord Zeus is trying to put forward here.
Definitely understand your position. However, I would like to seek help of Lizzie and Alex with this regard. We are talking about the choice of law provision or conflict of law provision because I think there's some sort of a gap. I'm talking about conflict of law, and I heard with regards to the choice of law, the aspect of party autonomy which you're talking about. But right now we decided that firstly we'll go into the picture with regards to the conflict of law. So if you could like summarize as to what is happening.
As per our understanding, please correct us if we're wrong. We have heard from this party that their basic goal in this entire discussion is that if a conflict of laws discussion is to take place, it will result in devolution of power. And from what we understand with your discussion, you want to, I would like to just add one small thing regarding their aspect first. They ultimately want to come to an agreement regarding the system that will be applicable for agreements between individual gods, and secondly, individual gods and mortals. So that is the agenda at your end. And for you, what we're trying to discuss is conflict of laws. The provision, it shall have three pertinent things to talk about. Firstly, that it shall act as a gap filling mechanism. Secondly, to have a divine legal code as a whole. And number three, you want to have a conflict resolution enforcement to take place. So what we understand of the situation is that you want to have a conflict laws system to take place for immortals, and you also want to have a conflict of laws system to be there for immortals. So I think that there is a commonality of both of your intentions of video. If there are any other doubts, please let us know.
And if I may add to what Lizzie has said, what hepatitis mentions is that in the absence of law, what they propose to do is that they want to have a choice on to which law will be applicable. Is that correct or is that wrong?
Alex, I am talking about the aspect of the conflict of law,
Right.
which is with regards to when there's no, when there's an absence of any existing law, how would the party move forward? So in that absence, in that regard, there needs to be some sort of an autonomy to be given. If I understand your position correctly, Zeus and Jackson, so what do you think would be the right mechanism? If you want, we can put a pin to it at this moment and we can discuss what you want at the first hand. Like if there's something which is very primary to you, otherwise you can continue the same discussion. Ambrose, if you have anything to add to this?
So, see, when we talk about giving party autonomy to individuals, we need to realize that the power also runs through the sovereign. So it's the sovereign that gives individuals the right key.
May I interject? Can you speak a little louder?
Yeah, sure. Also, I would also like to apologize for the fact that I might cough in between because the weather of the earth does not seem to be suiting me that well. Right. So see, first of all, we need to understand that the concept of sovereignty is not that fragile. That if you're giving individuals the right to choose which law should guide their contractual obligations, suddenly the authority of the sovereign is just going to fade away in the air. Secondly, like Hephaestus already mentioned, if you think that conflict of law provision is not the correct way to go ahead with, then what do you suggest should be the law in place?
I do agree with your concerns, and I do agree that the choice of law or conflict of law provisions that you explained are really do not in the end serve justice. I have a small story to tell, maybe cool down the environment. Yeah. So my son and daughter, when they were little, eons back, so they had a small, I won't call it a conflict, I'll call it a small fight. So it was Athena and Poseidon wanted to know that which one of them was more admired by me. So what they did was they decided to have a competition, and they sort of decided who the people would be, who would be the deciding factor in that competition. General public of a specific area. And what they saw was, in the end, Athena was, it was declared that Athena is the more admired one. But even Poseidon accepted to that judgment. Now, the reasoning is that they had pre-decided, he had submitted to the judgment. I might not be very clearly be able to articulate because being Zeus, I don't know what law is. I don't know how that law works. But this specific idea that I wanted to run through, maybe my counsel would be able to explain it more clearly.
Right. So if what I believe is that Lord Zeus is trying to put forward is what mortals call arbitration agreements. So basically, if I'm not wrong, that stories of how Athens came to be. Anyways, so the thing is that what Zeus has trying to put forward is that specifically for the first agenda between mortals, the disputes between immortals, sorry. So immortals, we all immortals have a duty to the cosmos, and we are duty bound by this responsibility that we have been given. And so getting into an arbitration agreement, as explained by Lord Zeus, is basically when they decide on something. Like it's much more like a contract wherein you decide that what will be the law applicable, who will be the jurisdiction, what will be the jurisdiction, and each party decides who will be the one arbitrator, and then those arbitrators can decide who will be the final presiding arbitrator. So in that way, that arbitration tribunal that comes to place is independent, and at the same time, it is not influenced by any of the gods. And as far as the decision of that arbitral tribunal is concerned, that decision is binding, and the gods, I think every god goes free and goes happy after such kind of an independent and judicious reasoning.
All right, Zeus and Jackson, I understood your position with regards to this. I'm really happy that you came about this very direct and upfront. So with regards to this position, what I am understanding and gathering is that you want some sort of a different mechanism, that's an arbitration agreement between the immortals to govern us, right?
Yes.
With regards to this, I feel that there exists a basic some queries which I have at the moment. You were talking about the tribunal aspect. Who will decide who will guide the tribunal? If the person guiding the tribunal themselves are at fault, how would they be the right person to judge their own cause? Won't this go against the principles of the divine immortal realm itself? And how will we ensure fairness and transparency in the process? I think these are some very pertinent questions which I wish to seek from you, Zeus, because you are the supreme authority and we are at your discretion. I'll be very happy to hear. Ambrose, if you have anything to add at the moment?
Thank you so much, Hephaestus. So, considering the fact that Zeus, you were the one who called for this great conclave, and we have seen that a lot of investment and time has been put by various other gods before the start of this sacred gathering in order to discuss provisions regarding a development of a choice of law conflict. And now, at the very culmination of the great conclave, you come up and you say that, no, let's put a pin on this and let's come up with an arbitration agreement. Why we are flexible to exploring the arbitration agreement, I feel like we need to understand more as to why are you putting a pin on a conclave that went on for 2 days regarding a solution that was completely different to this. And I feel like the argument of sovereignty does not justify it enough. So if you could explain your rationale to us a little bit more, it would provide us with more clarity.
Definitely.
If we may summarize and recap what all has gone back and forth. So Zeus, in order to create certainty and predictability, proposes a system similar to an arbitration agreement, wherein a party decides prior to the dispute, the jurisdiction, and the judges. Would that be accurate? Right. As a counter, what Ambrose and Hephaestus propose is that why a change in stance from the initial conclave, and they ask the rationale behind this decision. Moreover, the client asks what principles would operate the tribunal and prevent a member who has committed the dispute from arbitrating the tribunal. Moreover, would that be accurate? All right, so Zeus.
I do understand you. I feel like there are a lot of questions that have come up, so I will try to answer them one by one. On the impartiality aspect, I'm pretty confident we'll be able to devise a way that the tribunal is impartial. The nitty-gritties would maybe told me by my counsel.
Right. So first of all, I would like to thank Ambrose and Hephaestus for their questions. I think that is very important that we question any kind of solution that we come up, because as you said that this conclave has been going on for 2 days and there has been a lot of discussion. And I understand that pinning an idea that has been discussed for 2 days seems like a weird approach. But then again, we have to, like I said in the starting, this mediation is all about going to the heart of the matter. What is important for us? What is important for us that we devise the most efficient and the best method, the best system that could help us regulate the interaction, right? So why not try something else if it works? Now coming to the specific questions in regards to arbitration agreements. So first of all, for fairness, I believe that the arbitration agreements, they won't be specifying who the judge will be, not before the dispute. They'll just be specifying that each party will be appointing one arbitrator. I'm just giving an example. It could be different. So right, so it will just be specifying that each party will appoint an arbitrator, and then those 2 arbitrators will appoint another arbitrator who will be the presiding one. That way they have an equal representation, and then there's no influence on each other, right? And then there was second concern of the law, because you said that the choice of law then may be decided by the God himself. He will create the laws. So as far as that is concerned, I think that is addressed by the tribunal itself, because whenever there is no clarity or there was no pre-consensus as to what law should be applied in a dispute, then that the tribunal, which as I already explained, will be independent, then it can decide that which law should be applicable in order to show not only do fair justice, but it also shown that there is fair justice. So I believe that those were your 2 concerns. Is there any other concern that you would like to raise here?
Not at the moment. Firstly, I would like to discuss the idea with Zeus itself.
Please.
If that's fine.
Please.
Yeah. So Zeus, there's just one thing which I want to know like more clearly, as Ambrose put forward. The entire idea of divine intervention into the mortal realm and coming up with a conflict of law provisions because of the actions of Lord Apollo, your son, in the COVID pandemic, which happened. And this was your idea to call this conclave, this sacred conclave. And since the past so many sessions, we are talking about the conflict of law provisions. There has been a great headway with regards to the session of Hades and Charon, Aphrodite and Athena, Ares and Hermes. Despite that, all of a sudden, you change your provision, you change your position from conflict of law to arbitration. This is something, Zeus, although you are the supreme god, but we want to seek some clarification as to why do you want to change this position all of a sudden. And with regards to your suggestion, Percy, you talked about appointing the arbitrator. It seems like a very broad idea to me, and you talked about we will appoint an arbitrator and this would be very fair. But still we can't get the fact that who will appoint the arbitrator? Why? How will we ensure the impartiality of that arbitrator in the immortal realm when everywhere is God? Don't you think, Zeus, if I'll appoint another God in the immortal realm, it will lead to a lot of problems? We are not the mortal beings. We can't have such mechanisms. Every God has their own sphere of power. And within the sphere of power, how will we place a mechanism wherein the God in the underworld of the dead, where the Hades rule, how will we ensure that another person who does not understand that realm so well will be in a better position to understand? I feel that we should continue upon the talk about the conflict of law provision unless it is you can explain me the rationale as to why are you deviating all of a sudden after 5 important sessions which happened. So this would be something which we can have. Ambrose, if you have anything to add.
Hephaestus, I think you put the concerns quite well. However, I would also like to know that are you still open to the idea of at least considering conflict of law provisions to be a possible solution? Or are you completely closed off to the idea and do you just want arbitration to be the law that will guide us? So that's a clarification that I seek. Secondly, let's just say that we do agree to having this arbitration agreement in place. Now, even if we lay down certain guidelines, sometimes it happens that when there's a conflict, both the parties that were together suddenly sit at different ends of the table. And there are a lot of conflicts as to how will the tribunal work and whether the selection of the arbitrators has been done in a correct manner or not. And in such situations, there are actually certain principles in the conflict of law that can aid and complement it. So we want you to consider the fact that there are a lot of rules that comes into application when we devise the conflict of law provisions that might be applicable here.
Thank you so much. I feel like we tried to explain our aspect on the unfairness. If you could maybe, give me an example as to why you think that the arbiter will be unfair, because being a god, it's tough to understand the legal nuances.
Right. Absolutely. I would love to do that. But before that, if you could first clarify whether you're open to the idea of conflict of law system still being an alternative solution.
Is just one thing to add, because in the past 2 days, I've been listening to all the discussions,
Right.
very complex questions.
Right.
The reason I brought out an alternate form of dispute resolution was because we were not able to reach on a consensus. If you would have seen all the 5 meetings that we've had, mediation sessions that we've had, there's no consensus on what is to be followed. And as the mediators very well said, come to the mediation with open hands, clear mind, creativity. So we just try to add in a new, different creative set of dispute resolution mechanism. But we'll be open to listening your concern and what you think should be the way to move forward.
I feel like there's been a lot of passing of information, and there were certain points that were missed, which is, I think, important to the discussion, streamline it. So as Hephaestus pointed out, it was reiterated by the council, the 2 important concerns at the moment. The first is, just as you were answering, are you open to the idea of conflict of laws or provisions being discussed in the mediation today?
Yes.
But, all right.
And the second important aspect is something that was pointed out, that the proposal that was suggested by you of arbitration, those principles are also applicable in the conflict of laws provisions that they are proposing. So if both the parties are fine, maybe if this common ground will continue the discussion.
Thank you. Just a clarification, what I meant was that there are certain principles in the conflict of law system that are complementary to it.
All right.
Not inclusive, but complementary. We will talk about it later. How,
Complementary. They're complementary.
also, Hephaestus, do you think that right now would be a good time to maybe have a private discussion with Lizzie and Alex regarding certain reservations that we have at this point?
I think we are going back and forth and we're not able to understand. So I think a private meeting with Lisa and Alice would be right at this point.
So we can have it with the responding particles. Thank you so much.
Alex, if you could please close the door of the room.
Before we begin, I just want to reiterate what the session is going to be. That this will be a 9-minute session. And here I want to just tell you this is an added confidentiality to the session. So anything that you tell us will not divulge that.
Ambrose, would you like to have water?
All right. So I just want to state that this is a 9-minute session, and any information that you share with us, we will not be divulging that information unless you explicitly ask that of us. So please be open and please let us know what is it that has been bothering you in the discussion that is taken so far.
Definitely, Lazy. My position since the start, as I clarified in the opening remarks as well, was that there needs to be some sort of a conflict of law provision which needs to exist at the moment. And the entire idea of the conflict of law provision was of Zeus himself, the protector of all gods. I do not understand at this point why is he deviating from conflict of law provisions to the arbitration agreement. And it's going back and forth again and again. We are questioning, we are just asking him, requesting him to please tell us to what is his intentions. We can't get a clear answer out of that. Without getting that answer, how would we be able to formulate without even a formulation of a singular system? How can we go and jump to another system without even forming at the first place? Now, the aspect which Zeus told me was that since there is existing a lot of disruptions, there is no guarantee that while formulating the arbitration agreements, there won't be any disruptions anymore. Also, with regards to the various questions which we asked, how will you ensure, again, you are recommending a system of arbitration agreement. How will you ensure justice and fairness into that system? We are not able to get any sort of a clear answer with regards to that. Now, coming to the third and important aspect, which I highlighted, was that this can be complementary in nature. Like, we are not against the arbitration agreement at all. But there needs to be conflict of law provision. Even let's say that their parties decide with a party autonomy that they want an arbitration agreement. However, they are not able to form an agreement itself. There should be a provision as to how they are guided in this sort of a situation. So even if there exists an arbitration agreement, there still can be a chance where conflict of law provisions required into nature. And this is only complementary. We're not against the idea. However, we are not gathering enough information from Zeus as to what his position is. And I will really request you, Alex and Leslie, to gather this information. And if Zeus agrees, then you tell me again in the joint session. Ambrose, if you have anything to add.
I think you explained the concerns quite well. Also, a major concern that they had was that even though the conclave has been going on for 2 days, there have been no conclusive agreements. However, from what we have observed so far, there were actually certain in-principle agreements regarding quite a few nuances that would be applicable in the setting up of this entire provision. So, for example, there was a session in which it was decided that when it comes to applicability of laws, say in the cases of torts, the applicable law would be the law of the habitual residence of the victim. Then there was another instance where there was a discussion regarding, say, if there's in the contract, if the parties hadn't agreed upon a applicable law that will be in place in case a conflict arises, there was again an principal agreement that there can be 3-4 pointers and connecting factors that can be taken into consideration, like say performance of the contract, place where the contract was formed, nationality, language of the contract, etc. Then there was another conclave in which we also talked about the aspect of party autonomy, and Hades had in fact conceded to it and had accepted it. So this shows that that an entire precedent has been set in this great conclave that yes, we're going to sit, we're going to come here with an open mind, and we will reach a common consensus. So that's why we were caught quite off guard by the fact that suddenly they want an alternative solution that is extremely different. So that is something that we wanted to put forth on the table. And if there's anything else that you would like to add.
Just a last thing,
Yes, please.
Alex and Lizzie. With regards to the situation when Zeus come into the session, I just want you to ask basic questions as to what is the intention of Zeus from changing from arbitration agreements to from conflict of law provisions to arbitration agreements, firstly. Secondly, with regards to when there has been significant headway during the course of 5 previous discussions which various gods and deities have, the headway which we made, it would be of no use anymore. So rather than having this approach of erasing the entire headway which we make, we should do something which is complementary and collaborative in nature. And that is how when come to a system when an arbitration agreement may exist, but conflict of law provision, the headway which we make, how important it is, we know. So that suggestion should be incorporated, and that headway should not go wasted. The time and efforts of deities should not go wasted.
So if I understand you correctly, you are suggesting that the arbitration agreements may be complementary to the conflict of laws provisions that you're suggesting. So would you be open to the idea of perhaps stating this information to them that in a manner where the discussion can move forward? So would you be open to the idea of clubbing these two agendas into one and discussing?
Definitely, Lizzie, this is something which I'm open to. However, before that, I would like to know the intention of Zeus as to why he's fluctuating from the stance of the headway which we make since the last 5 sessions to the arbitration agreement. And I'm very collaborative and open, which I talked about in my opening statements as well, that this is here we are to collaborate. Here we are to listen to Zeus. He is the supreme god. So I am open to that idea. It's not a problem. However, I would like to know the intention of Zeus first.
And out of all the information that you have disclosed to us, is there anything that you would like to keep it hidden from Zeus and Percy?
I do not think you should reveal this to Zeus so that he's in a better position to understand.
All right.
So I just requested. Ask the response request. Thank you so much.
Since I see both the parties coming back to the room, am I right in assuming that you would not be having a private session with us? All right. Thank you for the clarification. So we did have some information that was shared to us. It was reiterated from the parties' end that they're open to the idea of course, considering that the arbitration agreement may be complementary to the conflict of laws provisions. However, there are certain concerns which I feel Hephaestus would be in the best position to talk about. So please go ahead.
Do you want to go first? Yeah. Talking about what happened in the caucus, and as my co-mediator said, Hephaestus would be in the better position to explain. I would just like to reveal one concern that Hephaestus has repeatedly mentioned is that they, a 50-50 solution is not by chance, and it's in fact both the parties moving bit by bit towards each other, right? So Hephaestus has shown that he's amenable to your idea of arbitration agreement, given that the provisions of conflict of laws are included in it because they feel that they are complementary, right? So they're interested in knowing your intentions as to why you want to go for the arbitration agreement path, considering that in the prior 2 days, in the past 2 days, we have made a significant headway with the conflict of law provisions. So they want a clarification on your intentions. They want to understand that we as mediators would like to understand that what is it that you feel that you can do for them to be more offer to your open to your offer. Noted, Ambrose. So, Sus, over to you.
Clarification. When you say that you want choice of law or conflict of law provisions to be supplementary to the arbitration agreement, could you please elaborate what provisions are you talking about?
Right. Do you mind if I take a priority? All right. So let's take a very simple example. Now there's a conflict between two courts belonging to different domains. There comes in a question of jurisdiction. Now, in case there's a conflict of law provision has certain rules that very precisely lays down how this conflict can be converged and which which jurisdiction's law will be applicable. In fact, let's take the example of the arbitration example that you gave, right? Now, sometimes what happens is that if there's a conflict in selecting the arbitrator, this is usually referred to courts. Now, which court do you go to? Because again, there's a difference in domain, there's a difference in jurisdiction. So in deciding this factor, we can rely on conflict of law rules. Because there are certain facts like, say, nationality of the parties, or where was the contract for, where the performance of the contract, or certain other connecting factors that we can definitely deliberate upon. Is there something else that you might like to add?
Thank you, Ambrose. Zeus, also, since you seek that clarification, after this, I would also like to know the intentions which the Alex put forward, which we have. Like, I want clarity with regards to that. If you want to, like, if you're free, if you are willing to, and let me know that why do you want this change of a position, and whether you're amenable to the complementary aspect of arbitration and choice of law provisions. Because as Ambrose mentioned, that choice of law provision only complement, even in the case where you're introducing arbitration agreement, even in that situation, there can be a need of conflict of law provision, as Ambrose just pointed out. So I would first likely to seek a clarification with regards to these two questions, because we are going back and forth again on these two questions.
Absolutely. On the first aspect, I have a few reservations on that. I'm not sure. So when you say that you want supplementary provisions, the example that you gave, the very reason that we want an arbitration to be in place is because it will be the deciding authority. It will be an impartial deciding authority. Now, if we have such rules complementary to it, it sort of defeats the very purpose of arbitration, if I'm not wrong. If you could please elaborate on that, or maybe my counsel would like to add something.
Right. So building upon that, essentially your concern was regards to jurisdiction. So what I feel is that we had the session of Aphrodite, right? So in that session completely was in regards to that only. So it had a aspect of commercial contracts. So Aphrodite was suggesting that in cases of commercial contracts, the place of signing of that contract, formation of that contract, shall be the choice of law in regards to the conflict of law system that we have to develop. Now, many problems with that were suggested and came up. Like we had the e-contracts problem, that how do these handle under such system? And in regards to that, I believe that arbitration solves that problem quite easily, because parties have that flexibility to decide it, right? And as and when dispute arises, they can, even if they have not decided it beforehand, they can leave it to the tribunal, and the tribunal will decide accordingly. And as far as your previous concern, you mentioned about the tribunal being independent. While I explained how that appointment is going to be independent, I'll also try to explain the arbitrators themselves, how will they be independent. So if I'm not wrongly interpreting your words, you thought that the gods will be the arbitrators themselves. Is that right?
I could not even understand, Alex, Percy, I'm really sorry, but I could not even understand as to how would this tribunal function, because it talked about the aspect of appointing the arbitrator, and this would give equal representation. I talked about the aspect, how will we ensure that the appointing arbitrator is impartial? It was not with respect to God, it was just a normal query.
Right. So the arbitrators will be, since arbitrators will, we can create a pool of arbitrators, just like we have for mediators right now. And mortals can be those arbitrators, and then those mortals may be trained in the particular laws or whatever kind of dispute is there. And those arbitrators then can function for any kind of dispute that does arise. And the gods have the choice to decide what arbitrator from that pool they want. Again, those two arbitrators, after being appointed, will appoint another arbitrator from that pool. And as far as their impartiality goes, I believe that that is something that will address that. Now, again, I have also a follow-up question for you. How do you believe that choice, like we had the Aphrodite conflict, how do you believe that we solved that kind of problem?
If I may seek one clarification from Zeus and Percy, and using the example put forward by Ambrose. So you mentioned that there will be two arbitrators appointed by each of the parties. And using Ambrose's example, what if these two arbitrators disagree on the appointment of the third arbitrator? Could you perhaps confirm on what principles will this conflict be resolved? Because I feel this is what is essentially in contention here. Using on what principles will the conflict between the two arbitrators will be resolved?
I believe that is something that we can discuss, and whatever you and I, Lord Zeus feel that is amenable for everyone and will be fair for everyone is something we can agree on.
I think at this point, I would like to request Hepetus and Ambrose to perhaps dwell into, and this is just a suggestion as a mediator, to dwell into the merits of your position, not to argue, but for the other party to evaluate the choices that they have.
Thank you so much, Alex, for the wonderful suggestion. Firstly, if I heard you correctly, Percy, you just said that mortals will be the arbitrator for the agreements being made between the immortals, if I heard you correctly.
Yes.
How will a mortal realm person, how will you bring that person, and how will you ensure that he would be trained to deal with the agreements between the immortals? Firstly, at the outset, I would like to know this. If you have anything to add.
Just to ask, so don't you think that this is going to bring a lot of interference in Mount Olympus? And also, there are a lot of things that gods deal with that pertains to the cosmic order. And to add mortals to it seems that rather than controlling and conducting interference in the mortal realm here, we are just increasing it.
At the outset, I feel like we gods are way more rational than other beings. So even if you disagree on that point, maybe we could discuss that one. What do you suggest? How do we go out with that? If not mortals, who can be the presiding authority?
I'd just like to interject here. I believe that in understanding the situation clearly, while you talk about an arbitral panel which consists of mortals, there is a need. The problem which has been pointed out is the jurisdictional error. So I think I would suggest that maybe that is a line of argumentation that could possibly taken forward if both the parties. Is that what we're trying to discuss over here?
Alex and Lazy, I'm really sorry, but at this moment, I'm not able to understand that the clear position of Zeus with regards to why there is a prima facie need from going to conflict of law provisions to arbitration agreement. How will we ensure this? And the idea of mortals being an arbitrator, I am getting this idea that whenever any sort of a suggestion is being made, there is no commonality. And then again, we are going again to the suggestions aspect. Firstly, I would at the outset just want this clarification whether it is very important and primary concern for you, Zeus, that arbitration agreement should be the only agreement to govern. I just want straightforward answers with regards to this. Secondly, I want to know that whether the complementary nature of conflict of law is applicable with regards to you. Do you think that we can have, apart from arbitration, because I am really open to your idea, apart from arbitration agreements, can we have a conflict of law provisions as well or not? Definitely, we can deal into the intricacies of the arbitration agreement, who is the arbitrator at the later stage. But at the outset, we need to understand this. I would just request you, Zeus, to, in one line, just clarify as to what is your position, because till this last 20 minutes, I'm not able to understand.
And adding to that, I think sometimes going forward involves taking a step back, especially when you're on cliff, considering the constant back and forth and the apparent circling around. I think we would like to for Zeus to answer this question as brief as possible, so the other party can understand Zeus' stand on the issue of choice of law as briefly as possible.
Absolutely. So I'll be very clear here, very straightforward. I have previously discussed why I think arbitration is a good solution. Considering that we've had sessions before, no solution, there was no consensus. I feel like arbitration is something that would ensure swift justice. Now, see, I feel like we've agreed on the fact that arbitration is a way forward. We can inculcate that if we, add your suggestions of complementary provisions, if that's right. We are open to discussing whether complementary provisions can be added or not. So if you could please proceed and explain how complementary provisions would be added. Then decide on.
I'm really sorry, Zeus, but if you could please just in the 2 points of concern which I just mentioned, could you just please give me a one-liner answer what is your position exactly? I still could not get. We can discuss the intricacies definitely, but I just need to understand what is the position. Ambrose, could you please put it succinctly, because we are again going back and forth.
So basically, we just need one clarification before we delve into the matter as to whether arbitration and a complementary system should be there or not. And that is, what was the rationale behind this sudden twist? Is there something that we are missing? But because even now, it just seems like after 2 days of continuous conclave, today we have completely come up with an alternative that was not even there in the aspects of other gods while they were discussing it. Also, there was a question that was put forth by Percy, which was lost in translation. So I would also want to clarify that. Now, regarding the question that was put forth in the mediation that took place between Aphrodite and Athena, I had a wonderful conversation with their trusted advisors after the culmination of the conclave, and they told me that there were some suggestions that were put in place to sort of dissect the problem. So they said that when it comes to the applicability of law, there are other principles of the conflict of law system that do help us to coincide that problem. For example, there are various connecting factors that can be taken into consideration. For example, place of culmination of the contract, performance of the contract, intention of the parties, language of the parties, etc. So I just want to reassure the parties that there are enough rules and there are enough principles of a conflict of law system that would be adequate in order to answer such questions.
Right. I believe that I can take the first question. So what Lord Zeus is trying to put forward in his position is, he came in this mediation with an open mind. He was the one who suggested the conflict law system, and he's of course open to it. He is suggesting another solution, as he explained right now, and why he is suggesting it. He explained because during these 2 days he felt that there was too much complexities. There were multiple options, multiple suggestions, and there was no consensus. That is why he believed that, as I mentioned earlier as well, that the interest we have to see at the main thing that we are trying to solve. It is not that we have, because we have a discussion on conflict law for 2 days, then we have to do it. We have more time. Gods can find time probably for such an important discussion. And in that spirit, he suggested another solution of arbitration. Of course, he is open to any suggestion that you have. And if at some point you can clearly show us how conflict law system is better than arbitration, then of course, I believe that Lord Zeus will be amenable to that. Am I right on that?
I'd just like to clarify one point over here. Earlier in the discussion, it was stated that you're amenable to a complementary solution taking place. But right now, I'm a little confused.
See, I'll
with
clarify
respect
it for
to-
you.
Yes,
There are
please.
3 positions, right? He's amenable to all 3 of them. Maybe if we can prove that conflict of law is better, then also he's amenable. If we can prove that a system wherein arbitration in complementary with the conflict of law system that they are presenting, that is also is amenable to. And thirdly, that purely an arbitration system that he's proposing. So all 3 of them are the options I think that we have on the table, and he's amenable to all 3 of them. Of course, the condition is which one is the best.
Into this, I feel like the second option that was an arbitration agreement with supplementary provisions. I feel like we've found a middle ground on that. If you agree with that.
This was my position since the start, Zeus, that there can be a conflict in nature. And this was something I have been trying to explain over the period, like Alex and Lizzie would have taken note of. So I just want to understand this position again, that you are ready with regards to having complementary aspects of conflict of law provisions with regards to arbitration agreement, right? Ambrose, if you have anything to add?
So first of all, I really appreciate how forthcoming your response was. I just wanted to know that you said that arbitration might prove to be a better alternative. So if you could kindly make us understand what are certain advantages that arbitration has over conflict of law system. And if the mediators could kindly take note of the fact that we have agreed on the fact that there can be a complementary system in place.
Certainly, we'll take a note of that.
Thank you.
Just a preliminary query, although we are open to answering that, but I feel like if we found a middle ground that, we can have complementary provisions with the arbitration, I don't understand why do we need to prove whether arbitration is a solution or not. Although we will answer that, please.
I'd just like to interject here. I sense that we seem to be going in circles. We agree on something and then we have a back and forth. So if I could just list down what was stated earlier. So first option that you're amenable to is a completely, if it is proven that conflict of laws system is better, then you're open to that. You're open to a complementary system of arbitration plus the conflict of resolution system. And if you can prove that an arbitration system is better, then an entirely arbitration system to be put in place. So from what I believe Alex and I understand, it may be prudent if the conversation was streamlined to discussing a conflict of laws provisions, because there seems to be some commonality there. And we can possibly move forward from that direction then.
Just to seek a clarification, Lizzie, but before that, we're in agreement that with regards to the arbitration agreement, the conflict, the supplementary and complementary nature of conflict of law provisions will be applicable, right? All right. Now we can move to the second part.
Yes, all of us are on the same page when we say that we agree on an arbitration agreement style of engagement for immortals, which has conflict of law provisions as complementary to that system. So all of us are in agreement. Can I have a thumbs up? All.
Considering the fact that a lot of nuance that we have to delve into, this is only an in-principle agreement.
All right.
Both the party, Lewis's as well as Hephaestus's
Yeah.
concerns have been met in an equitable manner.
Are the parties okay with that?
I'd also like to remind the parties that we do have a paucity of time. So even if we don't reach an agreement today, we can always move into further sessions. So please keep that in mind as you talk about the discussion further.
And with that, I think we can talk about the relationship of immortals with the mortals. If we are done with the first agenda, then we can talk for whatever brief period of time that we have left, right? So any idea, we just want you parties to just throw some ideas so the other party can understand your position and perhaps come better prepared in the next session.
This was your ideas used that you wanted some mechanism to be in place between the relationship between immortal and mortal. So I'm really happy to, I'm really open to hear what you want to say with regards to this.
Absolutely. I feel like when governing disputes between immortals and mortals, we could simply set up a relief fund which would cover all the disputes. For example, if we take the example of torts, a tortious act happens, we could maybe simply have a relief fund in which we'll have representatives from all the different people. And then they put forward their ideas, put forward their interests, and then we could accordingly compensate any tortious act that happens. So simply a relief fund is something that, we could move forward with. Maybe.
Just adding to that and clarifying a little. So what Lord Zeus is suggesting is that we create a divine relief fund wherein any immortal's tortious act which harm mortals or his interference in the mortal realm, they can be compensated through that. And for fairness of that compensation and that no one god is punished more than the other, we can do one thing, as he suggested, that we create a panel who decides it, and in that panel, us demigods with representing all the different gods can be there, representing the interests of all the gods in there, and try to keep it a constant, keep a standard wherein the whatever relief is given is not is equitable, is not harmful to a particular god.
Just to get this clearly, correct me if I'm wrong, Zeus. You're talking about establishing a divine relief fund wherein any sort of a tortious act which is committed in the immortal realm onto the mortal realm by any god, you'll relieve that mortal realm person by giving a sort of a compensation to that person. Let's say Apollo caused COVID pandemic. So you'll go and you'll compensate every sort of a person who got this pandemic. Is this what you're talking about? I just want to know your correct position with regards to this.
Not who caused the pandemic,
Uh,
but anyone who was affected by this pandemic.
So
A relief fund is what we're suggesting.
you are talking about establishing a relief fund to compensate. You talked about
The example that you gave of COVID, for example, everyone who suffered from COVID or was affected by COVID, under that relief fund, everyone would be compensated. So under that.
and this is because when you proposed this idea, you talked about the torts being committed. So it's only related to the torts aspect, or what is your understanding? I would firstly like to know before delving into this. Ambrose, if you could put my ideas.
Right. Also, when we talk about having a panel, you said that demigods will be a part of it. So are demigods only representing the 12 gods of the Greek pantheon be a part of it, or will all the gods of the Greek domain be represented? That's one concern. And when we talk about providing compensation, for example, as it was pointed out very correctly, there was a huge negative consequence of the COVID pandemic, and there were multiple lives that were affected in millions. So to compensate each and every person, and there was also a difference in the degree of pain that was suffered by each and every person. Don't you think this, while we appreciate the idea, don't you think it's a little bit more ambitious? While on the other hand, we did have a conversation before this session, but that is and we also have an idea, but that is something we would come back to after we hear these clarifications.
Should I take it?
Yeah, please.
Right. So I believe we have multiple questions here. Starting with the fact that that is an ambitious idea, I believe that it is beyond our understanding what the cosmic powers hold, these gods hold. So I don't think that is a problem. That's not that ambitious for these gods to handle. And as far as the demigods representation is concerned, I believe that this is a suggestion, and we are open to anything that you feel will make it more fair. As of now, I believe Lord Zeus has not decided on the fact that how many demigods will be there. Of course, he wants representation from all the powers. That is why as many demigods as possible is, I think, is what he's proposing. And what was your? There was one more question, I think, from.
Is about the number of victims. As an example of Apollo, the sheer number and volume of victims.
No, the other question I told already about the number of victims, that they have that kind of power. They are
All
gods.
right.
Another question was, I think, regards to tortious liability and otherwise, right? So again, as far as since this conclave started in regards to the interference, the tortious liability that gods should take up, since they are the duty-bound people for this cause, for these cosmos. So that is this particular suggestion in regards to that only. And any other kind of dispute that you are suggesting or you believe may be there between mortals and immortals, I think if as soon as you explain to us what those disputes can be, we can discuss on that as well.
Just adding to it, the reason we've suggested it under the tortious liability is because if you do the example that you just gave of the COVID-19 pandemic, so there's an urgency with regards to it. Just an example as to under those circumstances, such and such a thing can be done. You said that you have a suggestion on that. If you could please.
Before putting forward my suggestion, Zeus, if I get it correctly, you are taking back what you just proposed with regards to the Divine Relief Fund and with regards to the demigod being representative. What?
Tortious acts, we've suggested that. We've not taken that.
So your position is that you want the establishment of Divine Relief Fund itself, and that is to govern every aspect with regards to the compensation, if I'm right.
any tort that is committed, that is what will govern for any tort that is committed.
Just for clarity, what has been communicated so far is that in case basically a divine fund is to be to be instated, so that if a tort is committed, then the mortals can get relief from that fund. Is that correct? All right, please go ahead.
Thank you so much, Lewis, for clarifying that. I get what you're proposing at the aspect at this position. However, there are certain concerns which I have at the moment, and definitely we can take it up later. But Ambrose, would you like to put forward what solutions which we have so that he can have a better understanding of the aspect?
Right. So, first of all, with regards to the suggestion, right now we have certain reservations when we look at it from a reality testing perspective. Like, how will this actually play out in reality, considering the fact that there were millions of people that were affected? And this idea might come off as being too good in words, but in practicality, not spanning out and not actually impacting humans. So, what we suggested was that first of all, we need to have a codified set of principles that guide the actions of gods so that they're held responsible. This is something that we can deliberate upon in subsequent sessions, wherein we lay down certain guidelines that you cannot wreak havoc in the mortal realm just based on your personal opinions as to whether you were being worshipped enough by the humans or not, or just because you felt neglected by the mortal realm. So we feel like there needs to be a codified set of divine laws and principles that will guide the interaction between the gods and the mortals. If there's something else that you might like to add?
Zeus, this is something which I am proposing at the aspect, and I would love to hear as to what are your suggestions with regards to this. And with regards to the Divine Relief Fund, I feel that this is something which is the aspects of it needs to be highlighted, and we need to talk about it a lot, because it seems that it won't be very much practical that the actions of the gods in the immortal realm, how will it impact in the mortal realm? Who will assess what is happening, and how will the compensation be given? I would feel that rather your primary concern at the outset, when you called this conclave, was that there's a lot of intervention happening, and you were against the idea of substantial influence rather than basic influence. Because as gods, we have some duty towards our subjects, but you were only against the idea of substantial intervention, like Apollo did during the COVID pandemic. So I feel that it would be a better manner where we can formulate some guidelines so that substantial interference in the mortal realm, which is detrimental to the mortal realm people, would be addressed first. In that regard, we'll be able to save millions of lives, so that the aspect where Apollo feel neglected because there was no adulation and worship given to him, those sort of feelings are not there again, and there are certain guiding principles to such god. What do you think that how would this pan out?
I'd just like to interject here. We're very short on time. So I believe that this discussion can be taken forward in other sessions if both the parties agree to it. All right. So we've made headway despite despite conflict arising. And I think that in such situations, this is a completely normal thing to arise. But it's a good thing that out of the two agendas, on the first agenda, which was regarding dealings between mortals itself, we were able to reach an principle agreement that we will be taking into account arbitration agreements complementary to the conflict of laws provisions. And with respect to the second agenda, which was regarding agreements between mortals and immortals, it was suggested by the requesting party that a specific divine relief fund may be initiated. Of course, there will be more discussions on that aspect, while the responding party has also stated that they would want to codify certain principles so that immortals can be held accountable for their actions. So if there's anything that you'd like to add here, Alex, please go ahead.
Yeah, I think since you have pretty much summarized the agreements that we have reached and the debate surrounding between the divine fund and the codified principle that we will take in the next session, I would now like to request the parties to give their closing statements. Firstly, I would like to also thank the parties in the same breath for their time and patience. And, Rome wasn't built in a day, Olympus wasn't built in a day. Certainly, amicable solution would also take some time. So we can begin with the closing statements and thoughts of parties. We may begin, since we started with the requesting party in the opening statements, we can start with the responding party for the closing statements.
I would start with the fact that I appreciate that we did find a middle ground somewhere. The first concern that we had, we sort of found a solution on that, and I appreciate that you've come down to this mediation table with open hearts, and I appreciate that we found a solution. We had a very fruitful discussion. Thank you.
First of all, I would like to thank the opposing party and the mediators for being so facilitative, and especially the council. I believe that she helped us many times whenever there was a lack of communication between the gods. Also, I believe that I'll take an analogy here. Mediation, as I see, is a bridge between on a river, and agreeing on a principle is basically we have made a foundation for the bridge, and in future sessions we can probably make the bridge complete, and that is something that we need to do because the cosmos depend on it. Thank you, mediators, for facilitating this session.
First of all, I would like to thank Frezi and Alex for summarizing whatever happened in this 90-minute session so succinctly. Like there was a lot of information going on and on, but the way you summarize it, thank you so much for doing that. Now, I would also like to thank you again, Zeus, for calling me here and inviting me. And I'm really happy that with regards to the conflict of law provisions, we have some agreement in principle in place. And definitely with regards to your concern about substantial intervention to the mortal ill, in the future sessions, we can take it forward. Now, as Herundis said, that great deeds are wrought at great risk, but they take a great influence of time. So we cannot expect that these things to happen in a moment of time. But definitely in the future sessions, I'm very open to discuss this and to come to an amicable solution. Thank you so much for having me here.
Thank you so much, Alex and Lizzie, for facilitating the session with so much friendliness. And also, Zeus and Percy, thank you for being so forthcoming and for showing such a great spirit of collaborativeness. I think Zeus and Hephaestus know this, that they have been here since a millennia, and they have seen how much time it takes for societies to evolve. The same way, to come up with a new set of provisions that will guide us in the future will obviously take some time, and 90 minutes is not sufficient for it. So it was great to see that we have made sufficient headway and that we will require a lot more time in order to come up with a conducive set of laws. However, considering the fact that we have a very important in principle agreement in place, I hope we can leave this room with happy smiles and preferably travel back to Olympus together. Thank you.
Thank you. Thank you so much.
That's a Q&A round.
Just wait for Chitsa to drop back.
I think you should ask questions because they're running against the clock. To start with it, you can start Sheila when she asks for questions. Okay, I can ask one question to begin with because I think time is of essence. So, Zeus, can you tell me what was actually your arrangement of arbitration? How arbitration was to be done as per what they suggested?
So our main reasoning behind arbitration.
Sorry, yeah.
What there should be an autonomy of parties, also securing the sovereignty. So the way we've explained that to arbitrators, choosing one principal arbitrator to govern every dispute with which both the parties.
So what kind of disputes? What category of disputes?
Any dispute between
two gods?
Two gods.
Mortals not included?
Not included.
Demigods not included? Okay. And you will have mortals in this, like your friend rightly suggested.
That's a suggestion that wasn't told to us, but that was a suggestion that we could make to make it more impartial.
Okay. And everything, where will these disputes be resolved?
So,
where will these arbitration will take place where?
The location is not specific. That's
no, because choice of law was being discussed, right? The implication is the jurisdiction is what they were talking about.
The parties would decide on that.
Which parties?
The parties.
And what are the options? Gods have, other than Olympus, are there other options also?
No, only the Olympus.
So choice of law, what was the issue with choice of law? What difference would the choice of law would have made? Yes, please.
Right. So, sir, it's not like that it's only Olympus. So, as far as prop is concerned, we are not restricted by Olympus or anything. So, we see different domains of different gods. Plus, we have Olympus. Plus, we have the mortal realm, that is Earth. So, any choice of law could be taken up by the parties, just like in any normal arbitration. Either parties decide beforehand or at the time of dispute, and if they are not able to decide, then the arbitral tribunal can decide.
Okay, now question to the lawyer. So the Zeus, of course, is not a lawyer, like you rightly pointed. He was asking you for help. So as a lawyer, because he was in support of arbitration system, arbitration encourages conflict of laws, isn't it? Conflict of law itself is crucial to arbitration system. So
Right.
why were you opposing the idea of conflict of laws?
Right, so we were not opposing per se. I think that there was a gap in communication wherein they suggested that it should be in complementary to that, and we could not understand particularly what they meant by it, because we thought that the arbitration that we wanted, it had to have the party autonomy, and set certain rules through choice of law. For choice of law in regards to conflict rule system that we would have created was not something we wanted. We wanted the gods to have the party autonomy to decide what kind of law they want. So that was, and when later on when we did realize that a complementary system wherein we can decide this, that in the conflict of law system that we do devise, we can give the party autonomy in that system as well. So at that point, we changed our stance and we said ki we are amenable to all three of them.
Okay, thank you. Now question to the next team, quickly. You arrived at a settlement in this regard, correct? Now, what is the final settlement that has happened? How will it happen in the scheme of things that you have agreed on? How will the arbitrations take place now?
So with regards
What is the settlement? I want you to explain in a nutshell.
Settlement in with regards to our position is that there will be an agreement, arbitration agreement in place, and the choice of law provisions will only be complementary in nature, because our CI restricts us to the fact that we want want conflict of law provisions to exist. That is why I was going back and forth that whether this is primary concern or whether you are flexible with this. We weren't able to understand. That is why it took us so much time. Later in the process, we got to know that this is not something primary, but now since they were not agreeing, and our CI provided us with the choice that we can give a complementary aspect.
Understood what they wanted, or you still?
Yes, more or less, yeah.
I just have a follow-up question, can I?
Please.
So, if I correctly understand, if this was your agreement that you reached,
Yes, sir.
my question is, where do you draw the line between arbitration and conflict of laws, the way you are seeing? Like, what goes within arbitration, what goes within conflict of law? Is there a drawn pattern, or is there any identified area?
Yeah, and I want to build on that. Yeah, to the mediators particularly. What are the frames with it? Party autonomy. What the other expression?
Choice of law.
Choice of law.
Nationality. All those things they were talking about.
No, not nationality as much, but
Yeah.
more deeper concepts. Suitable law. What are the frames on which they're discussing? There are these concepts: arbitration, party autonomy, conflict of law, suitable law that we are discussing. What are these frames? What do these concepts mean? And under what frames are they discussing?
The way we understood it from their opening statement is like, and from the first agent.
You're saying you understood what they were talking about.
Yes, mostly. I mean, we also understood the communication gap that was there, but yes, majorly, yeah.
Understood that they understood each other? Was that your understanding?
No, there was an obvious communication gap. We concede to that. Like, I concede to that. She can she obviously is entitled to her opinion, but I can certainly see the communication gap between them, because the responding party, from the very get-go, they were very accommodative, and they asked, like, is the arbitration framework, is it something that's non-negotiable for you? Like, the priority or how important it is, and they were willing to lower their guard in order to include conflict of choice of law provisions to that. The what would, yeah, so sorry.
So on that point, I believe that there was, but from our perspective, to be very honest, I feel like there was a lack of clarity, which we tried to constantly try to bring forward, which was that there was a constant, in my opinion, there was a constant change of position and lack of clarity as to what exactly the requesting party, for example, wanted to communicate. So while there was arbitration proposed, the responding party did talk about the fact that these are certain principles that are already existing within the the conflict of laws provisions. Additionally, if you're, for example, there's a conflict between two immortals, the inclusion of mortals is self-defeating. So here we try to bring forward the idea of jurisdictional differences, but I feel like the argument did keep going around circles. So I do think that while an agreement was reached to, there is still a great sense of clarity that needs to be achieved.
A lot of the time was spent on determining, as Sir pointed out, that whether the arbitration agreement framework
And the conflict of law framework, are they like in a watertight compartment separate from each other? And so therefore we had to spend a lot of time going back and forth to that. But by the end of the, like in the second half of the session, I think both the parties were like in agreement that these are not watertight. Yeah, they and understood. I hope so. Yeah, in my opinion, yes. And if I may so just add to that, right? So we, while the counsel of the responding party, she rightly mentioned that we have agreed in spirit, right? So that leaves the scope of adding substantive like discussion to a later stage. So to answer your question as to what exactly includes, you know, the complementary provisions, I think, yeah, that. Yes, sir.
So that's why I asked to.
Yes, sir. So, sir, our position with regards to this was that conflict of law provision, our CIs tells us that conflict of law provision arbitration agreement, you can take it up complementary in nature. Conflict of law provision will only add flexibility and choice to the parties, and this would not be detrimental to their interest. However, you want a conflict of law provision to be in place. That is why, firstly, we only advocated for conflict of law, but we were flexible to the approach that even if you want arbitration agreement, it can be in complementary nature, and that is what our strategy was.
That's what exactly is our question. Are you clear about these concepts? Like what conflict of law generally means and what it is intended to mean in this?
Yes, sir.
Clear or those framed?
Yes, sir. Yes, sir.
If I may. So our understanding was that the conflict of law system, or let's just say private international law and international arbitration, are complementary. They're not something that go against each other. And our approach was that there are times when even in arbitration conflicts arise where you fall back on laws. Like, for example, sometimes when there is a conflict with choice of an arbitrator, like the final precedent arbitrator, sometimes this is referred to a court. Now, here the concept of a court comes. So therein we had mentioned, for example, when there's such a conflict, how do you figure this out? And this is where you lay emphasis on the fact that there are certain rules that have been laid down in the conflict of law system, like jurisdiction, forum non-convenience, principle of territoriality, etc., etc. So our entire point was that, okay, we can have an arbitration agreement, but in cases where there's a gap, choice of law conflict rules can act as an interpretative tool or sort of merge that gap together.
So may I present our understanding as well?
No, it's okay. I mean, others. I'm okay. I'm happy with the answer.
So I have very nothing to do with it. You guys chose not to run laws.
Right, ma'am.
It's irrational. What was your to not run laws?
Ma'am, so first of all, we felt that the discussion was going round and round. And they already had a caucus. And when we were outside, we decided that whatever offer they're going to, we're going to consider it very wholeheartedly. And getting a caucus at that point would eventually be if we were to discuss an offer with them, with the mediator, and then present them with the offer. And we did not have that much. I think there was only half an hour left at that point. And then it eventually would have led to then giving us an offer, and we are also giving an offer, and then asking questions back and forth. Them would have not been very productive. This is what we thought.
the opening statement posed in terms of what it is this whole mediation process. Do you think in that line did you settle or does ultimate agreement, even if we say principally agreed, does that match or they're interconflicting?
So, sir, the thing is that RCI presented the conflict of laws and that arbitration as detached concepts. As
You know, ask question mentioned what was performed here.
Right. So that is why we were in the first instance trying to say that we go for arbitration and everything, because in arbitration it was given that we have to somehow preserve party autonomy. Right. The gods will have the power to decide like what will happen and what law should be.
Is that was ventilated by your client with reference to what brings him to call this mediation? You are the investing partner.
Right.
So what is the primary investment which you have come? So with the interest that you are ventilated or articulated in the opening statement and the agreement which you have principally reached at this point, which they say that you did not object to, are they like each other or they're conflicting? That is what I want to.
Right, sir. So, sir, our interest was basically to make a system for regulation of interaction between gods and mortals. So, we decided in principle on interaction between gods, and we made an offer for gods and mortals, but we couldn't decide on it. To decide on a first we wanted to decide on it, and we had an offer in mind that arbitration should be there. So, sir, in
What was the purpose and what is the purpose of this mediation seems to be a little conflicting.
Sir, actually, that the CI presents as the conflicting.
Anyway, sorry. I have just sorry. I just want last question, which is in line of what Ikta has already asked. Then, do you think you, as mediator, have effectively used that tool of caucus?
To be very honest, I feel like the discussion as it was taking place, there was a lack of clarity on everyone's part. So for us, calling the caucus was more of a step towards understanding what they asked for. No, we did not. We did not. So it was called after we pointed out that there was a discussion was going around in circles, which is when. So I feel like in my view of the session, I felt like both the parties had a lack of clarity of what exactly was being asked of each other. If I were to take an example for in the beginning when the agendas were laid down, so the two agendas was that we need to discuss the agreement related to the dealings between immortals and mortals. But the discussion as it was taking place, it did not really refer to the dealings part as a whole, which I did notice was a gap. There was a significant gap in what they had proposed as their agenda and what was being talked about.
Questions for clarity.
If I may answer that. All right. So, building on what my co-mediator has said, there was a communication gap, and at various point we tried we understood that since you were not present there, we understood that initially the conflict was whether there's a watertight arrangement between arbitration agreements and conflict of law system. Thereafter, we tried to effectively guide the parties to so they asked for intention. I asked them to make a case, not necessarily a case for argument, but show the merits of their system so the other party can perhaps evaluate how these two systems are contradistinct towards each other, right? So my intention was for both the parties to present their the system, the mechanism that they're proposing, perhaps delve into the merits of the same, and then reach a common ground, which while it was not it occurred not in the most smoothest way possible. I feel like the conclusion was reached, but not in the most smoothest way possible. So there was an attempt from our side to answer your question, to in fact ask the parties. Yeah. Right. Yes. I think if I'll just speak one thing, right? The first thing in a caucus that you should do is like you ask the party what are their views on this session as it has like transpired till that point, right? That's what we did with them, and they were very upfront with it. They said that what they wanted was essentially to know the intention of Zeus, right? So that's the first thing you ask the parties as to what their comments are on the to like whatever it has transpired and what they would like from it going forward. And now my co-meet.
So that is exactly what I also felt. When we called for a caucus, we knew that the discussion was going around in circles. And for us, we asked them, what do you think has transpired up till now? And what is it that seems to be hindering the discussion as a whole? So they told us their perspective on what they wanted from the session and what kind of a communication gap they wanted communicated to the other party so that that can be bridged. And once we had an understanding of that, we thought that we could potentially go ahead with the discussion.
Add more of an observation, but okay. There was an additional feature in this, which is that you're allowed time to go out, discuss. Did you at all feel the need to do that separately?
Ma'am, I believe that we lost about that feature in the answering so many questions. And in retrospect, I feel that there was a point where we should have done that, but we could not.
Did you answer any of the questions?
Ma'am, I think we tried to address the choice, the jurisdiction part, and they had a question regarding that what is the intention. So he tried to put forward that his intention for bringing in this new concept is because he feels that the conflict law system that he suggested initially is failing. There is no consensus on it, and that is why he's trying to suggest a new system. But again and again, that same question was coming up, and I believe that his answer was not enough for the session. So that was a question that I felt was not answered. Otherwise, we tried to answer all the questions.
No, but why was there lack of clarity on your part if the mediator feels on the agenda that you had in mind, your interest? Why was there lack of clarity? Do you think, or you were clear in your what you wanted?
We were very clear on that we wanted an arbitration. That is what we proposed in the very beginning. But then there was a question of what our intention was. And we were not very clear on what our intention.
But why is that? That's exactly what I want to know. Why were you not clear on that?
There was one logic given to us that we sort of answered every time, but there was a loop. As to some additional information that they expected, but we weren't
restricted to your CI and all that.
Sir, I believe another reason was that while our CI told us to suggest arbitration, it did not restrict us. And so we, I guess, and that to them felt that we were changing our stance. We were like, we were only trying to put forward that we are open if there is a better suggestion by them to it. But it happened that whatever suggestions we made, there were questions on so many questions on that, and they never got a chance to make a suggestion. Probably.
I think we should have quick feedback from all the judges.
No, this is at a later session.
Okay, there's a later session for that.
After we mark it.
Okay.
So you asked a very specific question, saying that are you open to other suggestions? If they had said no, did you have a plan? That's question one. Secondly, in your CIs, there's a very personal phase. What was your rationale not really looking at things or bringing it back?
I'm firstly coming to the first aspect, that whether you're open to the suggestions or not. Their idea was that they want an arbitration agreement. We were not even clear that whether this is their primary concern or whether this is a non-negotiable. If I would have known it at the 10th minute, at the 15th minute, we would have got it.
Are you open to other alternatives? If they had said no, what was your plan?
To basically, RCI wanted a conflict law provision to exist. Then in that case, what we would have done is that we would have convinced them that then it would have come back, the burden would have come back on them that the conflict law, that the arbitration agreement is the correct form of method which should exist. Then we would have again gone on to the question strategy that these are the loopholes, and that is what was the negotiation strategy at the first place. That firstly, we'll ask them that whether this is non-negotiable for you, and then we'll point the concerns which we have, so that the other parties feels that even though this is something which we want, but there's no problem because as he said that a CI was not restricting us, then maybe they'll get an idea that yes, we can agree to this. So this was the idea. Coming to the second point, actually, you have added your point.
Yeah, just to add on to that. So in case there was unwillingness on their part, First of all, we would try to get to the bottom of it and try to understand where that unwillingness was coming from. And then we would also highlight how there are a lot of interpretative principles that can be used to strengthen and complement the system in place. And therefore, through examples, we could have told them that, listen, your interest is not totally detached from what we are asking or from what principles we want there to be in implementation. And maybe through that we could have reached the consensus that we both the parties want a good system of law to be in place. And if we have principles that can help us, because we gave some examples as to how there can be certain gaps where we will have to rely on some other principles that we can find in the conflict of law system. So through that, we would have sort of brought both the conflicts together and see ki, listen, this is complementary. So maybe you can be a little more accommodative and try to understand that your interests are being protected here. And in fact, we're giving you a cushion, more complementary laws that will act as an interpretative tool.
To your CI.
Ma'am, with regards to the second question, the CI used that case as an example only. Yes, ma'am. Coming to that aspect, the CI used that case as an example only that this is some problem which you are facing at the moment, and with regards to the Hermes situation, and that is why that there does not exist any sort of system. You want a system by, and you'll request Zeus, like in the last time, you would convince Zeus that you be a bold and visionary leader again. For while arbitration system is a fine system, conflict of raw rules will also complement it because they will only add flexibility and choice. So our primary agenda herein became that we get conflict of law. Even if we don't get, we get it in a conflict in a complementary aspect, and that is what a negotiation strategy was all about.
Those are during your caucus or anything, you didn't bring that up.
Yes, ma'am. Yes, ma'am. With regards to that, we had even I planned it to give it in the opening speech itself, but the way things were going, it was became very important for me to address that. Firstly, you clear these three aspects so that we could even talk, because at the 55 minute we were not even sure what the other party wants. Thing, it would have only added complexity to the situation which existed.
Feedback is now, right now?
Yeah, just give me a minute.
This is the only time, right?
No. Just give me a minute.
Yeah, take your time. Yash, take score sheets.
Yeah. But she's Shall I go?
Yeah, please go.
Never mind all this battering about questions. I think all of you did a remarkable job. It's been very, very excellent quality work. I say this particularly because this is a very interesting problem. It was also very difficult. Okay, because you can plumb the depths, there's a vast expanse in terms of breadth, and to be able to sort of work out your interests, work out what your strategy is going to be, and all of that would have been very difficult in 1 hour. So I think, given that, I think it was excellent on all your part. For the mediators, I think you need to understand and to help parties and to facilitate, you must understand. And therefore, you could have questioned them on what this is, what the meanings are, ask them to articulate. You lost control of what was happening. You had to manage it. You were not in, you weren't managing it at all. And there were questions, and questions, right? And no one knew where things were going. Right? So that's for you. For the parties, I say you have that information with you. Examine, what you can do with it in terms of what is your position, what are your interests, how do you understand this? How do you understand what conflict of laws is? You are, from what I understood, from the confidential information, Zeus is looking at there are problems with the existing system. How do we work out a new system? That is why the conclave is called, right? Now, you should be able to justify why you've done this. You should be able to sort of explain, be able to sort of defend it, know what you're asking for, etc. Some more, right? There was a lot of questions back and forth, but no one really explaining, look, this is why I say what I say. Questions were answered by questions were answered by questions. That was, I think, a substantial portion of what happened. Use of caucus, use of separate discussions could have been done a little more. That's it. Great work. Thank you. I'll just add to what you just said. It's, when you're the how do you solve? There is question. So, but how do you do that? You were probably asking questions on top of it, rather than taking that pause to say, okay, fine, have we understood? And there were questions that were getting deflected. The questions that were getting missed out. If you just taken a pause and said, okay, is this how you want to explain it? Is this what we understand? They would have also gotten clarity at that point. So that pausing, and not, when you're talking about summarizing, there's also something about how you rephrase it. How do you rephrase it? How do you make it, how do you break it down simplistically so that they are able to confirm, yes, this is what we meant. And they're able to understand that probably this is what they meant. So I think there it got a little lost. Caucus. So while they will explain what they want to say, you can also use that opportunity to figure out if there is this back and forth happening, there's no clarity there. Are we missing something? What is it that you really wanted to understand? It need not be, you're not limited by what they want to bring in. So, and the second thing is, when you assumed that, when they went in, they will also do a caucus, you had the ability to call for a caucus as well. So using that, so you're not limited by only parties calling for a caucus. As a mediator, you could also. So if there is confusion in the room, you have the ability to also sort of control that. With the parties, there was a lot of, when you look at it, why is US really asking for the change? Okay. And why are you looking at, an arbitration? Why does it affect you? See, when you're talking about a mortal realm, does the mortal realm even bother you? Okay, and why is it there? So you, on one hand, you want to be true to your word. On the other hand, when I ask the question about your things, you're also concerned about your contract. That in this entire thing, something might get lost out. So when you make it artificial and above, you're negotiating on positions. So that happens as to why do I want to understand a conflict of law, choice of law? Does it really matter as to how you're phrasing it? But what's your real interest? Why are you on the table? Why do you want this change to happen? Or how do you want the change that they're looking at to be modified? So unless you get into that and ask questions which are underlying, you'll always talk about it at a very superficial level. So go deeper into what it is. And but hats off, this was, even when we were looking at the problem, we were confused. So what hats off. So this was a great challenge and well done.
I mean, much has already been covered, but just few things which I want to add. To me, it was looking more like negotiation at some point. I think the facilitation part could have been better, especially afterwards, when each of them started throwing questions at each other. They were asking, what do you want? I'm not getting clarity. I think half of the time we had already spent. And again, he was asking, what is exactly are we discussing? I don't have clarity. And they were saying that this is what we want. You tell us, what are you suggesting? I was just hearing this. See, all of you have done a good job in terms of you understand the process. There is no question. And you are in the finals because you have done an excellent job. So I know you understand the process of mediation. You know what you were doing. Opening statements were perfect. When it started, I was extremely happy to see the teams. But somewhere, I don't know what went wrong. Maybe you all were yourself not clear. Maybe the CI restricted you or the fact sheet did not give too many details what exactly you want. But like Ekta rightly said, what you could have done is, be a little more creative and identified more options. Why do you want this system? Like, you have to ask the effective questions. I think that part was missing. So this was more like an ambiguous goal which you were trying to achieve. Usually in arbitration, they say public policy is like an unruly horse. Once you astride on it, you don't know where it will take you. So this mediation at times, made it feel like you all were just not knowing where you are going. And I don't know how you settle on what terms. Still, I'm not very clear. Probably I'll meet the two of you and understand how it's going to work out. But you, as a team and as negotiating pairs, you have done an excellent job. And the mediators were really good in opening statements. Later on, you, I think, could not control. But still, the job you have done an excellent job. Please give them a round of applause for excellent work they have done. Really, good job.
Good job to all the participants. Really impressive.
I'll also be very short because I think, my colleagues have explained everything very candidly. I think one point is, if I correctly understood the problem, that this was a build-up of the whole process from the beginning to end. But somewhere you missed that and you were focusing only on the final CI. So the final CI was not the key. The key, I got the clue because when we were reading first time, I got a little bit probably a clue of this because I had the opportunity to judge the semis. So I had one CI. Yeah, so I think what was more necessary was to bring your experience of the other, especially why I'm saying that, where is my clue from, is why I asked you this question, that your interest here, if you say that has been solved by the settlement you reached here, or at least principally agreed, then that goes against the whole idea because you are the person who called this entire conclave. So there's an inter-conflict. So because of the 4 rounds, what happened? You are not happy. So you wanted to revisit your principal decision that whether you are correct in calling the conclave. And that's what, somewhere that part was not missing. And I understand it is fair enough. If I was given 1 hour before this kind of a thing, I would have done even much worse than that. So hats off what you performed. 100% it was. But as a point of feedback, I'm telling you that, in this kind of, I told this earlier also, I think, this mediation model is, advance of its time. The mediation competition. It's before its time. So I'm sure none of us are probably used to this model or experiencing this model. So that was a challenge, but the way you handle the challenge, hats off. So thank you very much.
Counsel and client coordination, again, very important. There were times where I felt the client said something and the counsel, instead of supplementing or complementing that information, took a new string altogether. So what happened is what the client was trying to address, or the client query sometimes just got lost and the counsel's query became the paramount one. And that sort of continued till somebody said, oh, wait a minute, I need to be heard. So client and counsel coordination also is extremely important. Thank you.
Thank you so much.
Unless you have any feedback for us.
Or anything other than asking this.
No feedback. That's the job.
Thank you. Thank you, everyone.
She's saying it's will be kind of cool. So. You're going to very good job. अरे ये मैं देख उसके कुछ करना
Hello, a very good evening to everyone present here today. At this very special moment, I'm reminded of the timeless wisdom of Dr. Seuss, and I quote, "Sometimes the questions are complicated, but the answers are simple." With the conclusion of the grand finale, we have reached the final stages of the third edition of Nalsar Mediation Tournament presented by Cyril Amarchand Mangaldas in collaboration with IMC Hyderabad. To state a brief about ourselves, Nalsar University of Law was established by the Andhra Pradesh Act 34 of 1998 as a fully residential national law university offering an integrated 5-year law course program. Indisputably, Nalsar counts as one of the best law schools in the country. The IDR culture at Nalsar has increased many folds over the year, which is evident by the stellar performance and participation in national and international competition over the years. Teams of Nalsar have performed exceptionally well at international tournaments such as CDRC Vienna, TNC, Hong Kong, ICC Asia Pacific, CPR Mediation Brazil, and it gives me immense pride to share with all the participants present in this room that even today, Nalsar is the only Indian university to hold the ICC Paris Championship trophy, which we won in the 18th edition of the tournament. The Nalsar Mediation Tournament The Nalsar Mediation Tournament at its third edition this year echoes the resounding success with the participation of 24 national and international teams. The tournament has been graced by the esteemed presence of judges holding vital positions in renowned law firms, law chambers, academia, mediation institutions, etc. One of the most important highlights for this event was our partnership with Cyril Amarchand Mangaldas as the title sponsor for the event. Before proceeding, we would like to convey our warm gratitude to our title sponsor, Cyril Amarchand Mangaldas, one of the India's leading law firm with over 1,000 lawyers, 6 pan-India locations, and an office in IFC, Gift City, and Singapore. CAM is India's largest full-service law firm, staying ahead of the curve with their ability to provide future-focused end-to-end solution through domestic and international collaborations. Although he's not present today, but we as the organizing committee wanted to specially mention about Mr. Lomesh Kiran Nidumuri. Lomesh sir heads the disputes team of South India at Cyril Amarchand Mangaldas. He is part of the dispute practice leadership of the firm and a key member of the international arbitration practice. Lomesh sir played a great role in ensuring the partnership between Nalsar and CAM. And we are really, really thankful to CAM and to Lumesh sir for their continued support throughout this journey. Additionally, we would also like to thank International Arbitration and Mediation Center for their continued support throughout this journey. We have received this support and assistance at each step, and we are really grateful to them for this support. We are also thankful to Mr. Mohit Mukal and to Mohit Mukal Mediation for offering training courses to the participants which came for the third edition of Nalsar Mediation Tournament. We would also like to extend our warm gratitude to our exclusive media and knowledge partner, SCC Online and EBC. This event would not have been possible, most importantly, without the constant support and guidance of our problem drafter, Mr. Romit Sarkar. Mr. Sarkar's experience not only fully ensured the smooth execution of the event, but also added a touch of excellence that elevated the entire experience. We immensely thank all the stakeholders for helping us and supporting us in our endeavor to present a new flavor to the mediation practice. As we conclude the third edition of Nalsar Mediation Tournament, I'm reminded of the words of the great American author Margaret Lee, who said, "Conflict cannot survive without your participation." With mediation, negotiation, and conciliation seen rapidly evolving on a global stage, as well as in India, the Nalsar Mediation Tournament seeks to provide a unique opportunity to students across India and international. The model adopted by tournaments provide for a complete resolution of a single conflict from the very beginning till the end, which is our unique selling point from the first edition. And we really hope the teams enjoyed the experiment which we tried to did, and we'll further refine and work upon the new experiment which we have tried to introduce in the Indian legal domain. We'd also like to thank all our esteemed judges for the finals. We are really, really grateful to Chitra ma'am who have come down all the way from Chennai to help us in the smooth conduction of this event. Chitra ma'am is a lawyer, is an independent private practice, and a mediator with over 20 years of experience in corporate commercial law, both in transaction advisory and dispute resolution. A trained and certified mediator, Ms. Narayan has mediated commercial, corporate, and family disputes for over 16 years. She is also the author of the book Mediation Policy and Practice. It is with great anticipation and gratitude that we welcome Ms. Chitra Narayan. We look forward to gaining insights from their wealth of experience and expertise. Thank you so much, ma'am, for coming to Nalsar. We are also very grateful to Professor Anirudh Chakravarti for coming to Nalsar for the successful conduction of the third edition. He has a professional legal career that spans over 18 years and have a diverse settings and has in his basket, starting as an advocate in a solicitor firm at Calcutta, and then he switched to academia in 2005. He joined Nalsar University of Law in January 2021. He has worked with UNDP as a project manager in the Access to Justice for Marginalized project and as a consultant to the Department of Justice, Government of India on deputation. He has also been awarded the Fulbright Fellowship in 2009. Thank you so much, sir, for coming to Nalsar. We also like to thank Ms. Ekta Bhel. Ekta ma'am is a partner with Samvad Partners and is the partner in charge of the Hyderabad office of the firm. She is a corporate commercial lawyer who has significant experience in corporate restructuring, insolvency, private equity, M&A. A qualified mediator, Ms. Ekta has completed the 40 hours mediation and negotiation training from both the Indian Institute of Corporate Affairs and the International Center for Alternative Dispute Resolution. Ekta ma'am is also empaneled as a mediator with the Center for Mediation and Conciliation, which is an initiative of Bombay Chamber of Commerce and Industry. We thank you so much, ma'am, for coming to Nalsar. And we are also really, really grateful to Emil Joseph, sir. Emil, sir, is a graduate from National University of Advanced Legal Studies, Kochi. Joseph, sir, not only fully holds the prestigious title of a legal professional, but also brings a wealth of experience as a company secretary. Presently, sir serves as a partner at the esteemed Cyril Amarchand Mangaldas, where his expertise and acumen contribute to the success and growth of the firm. Mr. Joseph has forged an impressive career path, having previously lent his skills and insight to reputable legal establishments. His journey includes noteworthy tenures at Tattva Legal and Trilegal, where he made significant contributions to the legal landscape. His diverse experience across legal domain have shaped him into a seasoned professional with a nuanced understanding of the intricacies of the legal world. We thank you so much, sir, for coming down to Nalsar and helping us conclude the final match. We also have a very, very special guest with us today, Honorable Justice Sam Koshi. Thank you so much, sir, for coming to Nalsar. We welcome you with warm heart. I'll request VC sir to kindly present a bouquet to Justice Koshi as a moment of gratitude. Having honed his legal expertise through years of dedicated practice in the esteemed High Court of Madhya Pradesh at Jabalpur and later in the High Court of Chhattisgarh at Bilaspur, Justice Koshi brings a wealth of expertise in civil, constitutional, and service and labor law. His legal journey has not only encompassed the intricacies of the judicial system, but also extended to the advocacy on behalf of various entities. His commitment to the legal field and diverse experiences have positioned him as a distinguished jurist. Currently, we are honored to have Justice Koshi as a judge in the esteemed High Court of Telangana. His presence here today adds a unique perspective and wealth of insights that undoubtedly enrich our gathering. With immense privilege, we extend our warm welcome to Justice Koshi. We now request him to please share his wisdom and thoughts with us. Justice Koshi, please.
A very good evening to each one present over here. The learned Vice Chancellor, Ms. Chitra, my friends from the legal fraternity, team from the Cyril Ahmad Chand Mangaldas, and all the students. It's really nice to be in a college campus always. You're reminded of all those old days. It's a great feeling to be part of this valedictory ceremony of the third Nalsar Mediation Tournament 2024. It's also heartening to learn that the legal firm Cyril Ahmad Chand Mangaldas is also rendering their wholehearted support for this tournament that is being convened. And also the other stakeholders who have taken the pains to be part of this tournament, which really nourishes and encourages the students from the National Law University to learn the intricacies of the different fields of law, and one such topic being mediation, one of the branches under the ADR. So far as Nalsar is concerned, the little association that I have for the last 6 months of my tenure in the state of Telangana, I have witnessed that Nalsar has emerged as the forerunner in terms of the student engagement and the achievements in overall developments of a student pursuing the legal course, more particularly in the field of ADR. I have witnessed stellar performances of this institution on various subjects throughout the tenure that I have had, or at least I have got to know about it from the news letters that have been circulated. I can proudly say that it has really emerged as a torchbearer to various other institutions imparting the legal courses. And it has all made its presence felt both in the national and in the international arenas, particularly when there are so much of competitions being held both at the international and national level. All this require a special word of appreciation to the Vice Chancellor, a remarkable personality in himself, rich and varied experience, known for his dynamic leadership. His contribution has been unique and extraordinary. Someone has said that best bosses inspire and influence through their caring and authentic leadership and their exceptional interpersonal skill. Dr. KDR, as he is popularly called, and if I can take the liberty to use that term, is one such boss, and the results are evident. As far as ADR is concerned, particularly the field of mediation, I'm sure each one of us is aware of the judgment 2010 Supreme Court AFCONS, where Justice Ravindran has threadbare dealt with the subject and has given the interpretation on the field of mediation. It has emphasized the importance of ADR and also the importance of considering ADR as a process before undergoing the full process of trial. It dealt with Section 89 of the CPC, came out with an interpretation that there can be 5 ways of settlement of dispute outside the court. One was the adjudicatory process, that is the arbitration. The other 4 were non-adjudicatory, that is mediation, conciliation, settlement, judicial settlements, and the settlements made before the Lok Adalats. All were non-adjudicatory process. Mediation, as we all know, is an area which is deeply rooted in our cultural and historical fabric. And it bears the testament of our belief in the power of reconciliation and compromise. What is mediation? Mediation is just about finding a solution to a dispute. It's about healing relationship, fostering understanding, and promoting peace. What is the role of a mediator? The role of a mediator is, one, facilitating communication between the two parties, helping the parties to understand each other's perspective, and three, guiding the parties towards a resolution and address their respective needs. And ultimately, mediation aids in, one, reducing the backlog lying in the courts for days, months, years, and even at times decades. Two, ensuring that justice is not delayed. Three, offering a more understanding solution between the parties. And four, providing for a conciliatory approach to a conflict resolution. It enjoins the disputing parties with the mediator to find a mutual ground, encouraging resolution and arriving at a settlement where both the parties go in a win-win situation. Mediation is nothing less equivalent to be a deity. Such a power is reposed in them which is no less godly. Non-judgmental acceptance of every human being is a critical and practical tool in mediation. Most religious and spiritual practices advocate a non-judgmental approach. The Vipassana mediation is also about observing oneself and others as well, without judging the other. A mediator knows that he or she will never get to know the entire truth, and many things would still be unclear in the conflict. He is not guided by the Civil Procedure Code, nor is influenced by the Evidence Act or any of the rules or laws that are framed by the government. He does not have to form opinions, nor is he required to render any decision. He has to take humans as they are, laden with all their shortcomings and strengths, which coexist in all human beings. He only needs to facilitate the discussion so that all the cards are laid on the table, and either of the parties to the dispute take out the best that would come in their share. The mediators become instrument of peace, develop within them a peaceful atmosphere, an attitude towards the life. We are all aware from the mythology that we know, Mahabharata, that is an example that is given by practically everybody who has ventured into mediation. We know in the dispute between the Pandavas and the Kauravas, who had mediated? Lord Krishna. So it is not new that we are trying to experiment or explore. It has been there since the time. In the holy book of Bible, there is a verse which says, "Blessed are the peacemakers, for they shall be called the children of God." And the role of the mediator is nothing less than that. What has to be seen is what ultimately is the outcome of their endeavor that the mediator makes. As we all know that the new Mediation Act 2023 has been enacted. The aim of the new act is to expand the scope and the statutorily recognized pre-litigation mediation, online mediation, community mediation, and conciliation under the definition of mediation. It is a little bit technical. There are certain stages which we need to understand for a mediator to have a strong grip on the subject that he is dealing with or dealing with the two disputing parties. The stages of introduction, the opening statement, the joint session, the separate session, and the closing session. All these have their own importance and values, and each has to be undertaking so as to get the result that is expected from a mediator, the result that is in the mind of the two disputing parties. The integration of mediation into the new law schools curriculum speaks to its growing stature within the legal framework. It provides you, the future legal practitioners, in various ways, whatever field that you have chosen to be at, be it in the corporate field, be it on the litigation side, be it on the judicial service side, all. As future custodians of law and justice, each one of us present in this hall have an important role to play in maintaining and furthering this tradition and art of mediation and the knowledge in the field of mediation. Round the clock, across the four corners of this hall, premises, state, and the nation. The consistent encouragement from the mediation, for mediation from our judiciary, right from the Supreme Court to all the courts downward, speaks volumes of its importance, relevance, and effectiveness. Guidelines and procedures have been framed, training courses have been modulated for the mediators to undertake, and mediation have also taken significant steps to set up centers across the country, and a few of them are present within this hall itself who have sponsored, who are closely associated with this. For the students, I can only say that the next generation legal field is in your hand. You have the potential and the opportunity to shape how conflicts are and how these conflicts should be resolved in a society. Embrace mediation and make it an essential part of the legal toolbox. Master its techniques and use it as a tool to bring out the legal solution, meaningful, and a lasting resolution. This is not just your responsibility as a law student, but also your opportunity to make a big impact on the society and in the growing disputes and the number of disputes in the society. A harmonious society is a collective effort, and every successful mediation brings us a step closer to that goal. As you embark on this journey, remember that the role extends beyond just being a legal consultant, a lawyer, or a judge. You are peacemakers, healers, and facilitators of an understanding that can resolve issues which may be simple but which is made complex by the system and by the society. You have the potential to shape the future of the society where disputes are not just resolved, but are also transformed into opportunities for growth and understanding. So embrace this opportunity and the responsibility with open mind and heart. Master the art of mediation and use it to bring enduring resolutions that heal and unify the disputing parties. At the end, I can only congratulate all the students who have come out with flying colors in the competition that was held the past couple of days. Some may be winners, but those who are not winners also should not feel that they are, because that is what mediation is. Everybody who has participated should leave and feel that they have gained, they have learned, and this would be part of their system for all times to come. Thank you.
Thank you so much, Your Lordship. Your words were truly motivating for all of us, and it definitely adds a lot of depth to our knowledge pool. Thank you so much. We have Ms. Chitra Narayan with us today. We are really grateful to have your presence, ma'am. Can I please request VC sir to facilitate her, and I'll request Chitra ma'am to please address the gathering.
Justice Koshi, my teacher, Professor Sri Krishna Deva Rao, and friends here. I didn't expect to be asked to speak, so I'll try and make it short. This is my first visit to Nalsar, and I've been impressed from moment one with the quality of the problem that was there for the moot, and the quality of the way it was organized. The efforts taken by the students, by the Media Association. It thrills me, when I see the number of competitions that are there for mediation in law colleges. It also thrills me to see the quality of mediation that has grown. I've been judging these for some years now. It earlier started with, the participants showing a sense of collegiality, smiling, nodding, but it's become more powerful, the quality of the participation of the students in mediation. And I'm extremely grateful because you are our future. You are the future of mediation. And it's very, very heartwarming to see that, you're growing in this, and both in terms of quality and in terms of number of competitions in mediation. The Bar Council of India has taken note of the importance of mediation and made it a compulsory part of the curriculum for LLB. And I'm really hoping that when more of you graduate in the years to come, you will look at yourself as Justice Koshi very powerfully put it, as healers, because that is what we are. We should never forget it. We're not here for a sport. We're not here for jousting, like Justice Pound said, that this is not a gladiatorship disputes and their resolution. We're not sort of battling procedure, battling our, one version versus the other. Disputes are not binary, they're very multidimensional. And we should acknowledge that this is our primary role. Our role is as a healer. And I hope, this will be the norm and that we will never have to repeat a word like this because that is how we will function. I also want to thank Cyril Amarchand Mangaldas. I've seen every competition, virtually every competition where they're supporting mediation and the younger generation. Thank you everyone for having me here. I'm so pleased to be.
Thank you. Thank you so much, ma'am. Thank you so much for your encouraging words. In this room today, we also have a very special guest with us today. We have Mr. Tariq Khan sir present here. Tariq sir is a seasoned dispute resolution practitioner having a strong background in alternative dispute resolution and a keen understanding of international arbitration practices. He was appointed as the partner of a prominent law firm, Advani & Co., New Delhi, in 2021, and is currently the registrar of the International Arbitration and Mediation Center, Hyderabad. Sir, over his course of career, has worked on over 50 complex and high stakes arbitration, both domestic and international, across a variety of industry, including construction, infrastructure, energy, joint venture, and intellectual property, and worked with clients from across the world. Tariq sir has been listed in the Forbes Legal Power List 2021 as one of the top individual lawyers and youngest lawyer listed in BW Legal 40 Under 40 2020. He was featured in Fortune 500 magazine for Authority as the best-selling book on the rise. It is with his constant support and contribution of IAMC that today Nalsar is presenting the first edition of Nalsar IAMC Journal. I'll now request VC sir to please come forward, address the gathering, and release the first edition of Nalsar IAMC Journal. Please, sir.
I'll just. Honorable Justice P. Sam Kosi, sir. Honorable Vice Chancellor, sir. Chitra Narayan, ma'am. Tariq Khan, sir, Registrar IIMC Hyderabad. Ekta Bahal, ma'am, Partner, Samvad Partners. Vikram Puserla, sir, Senior Advocate, High Court of Telangana. Anirban, sir, I would like to call our former professor at Nalsar, and other respected faculty members, esteemed guests, colleagues, and my friends from Nalsar and other colleges present here. A very warm good evening to all of you. I'm Piyush Raj. I'm the managing editor of Nalsar IAMC Areas Journal. I stand before you today with a great sense of honor and excitement as we gather to launch a new chapter in the realm of knowledge and scholarly discourse, the unveiling of Nalsar IAMC Areas Journal. This marks a pivotal moment in the realm of dispute resolution and legal scholarship as we embark on a journey to explore, document, and elevate the field of alternative dispute resolution. The Nalsar IAMC Areas Journal is the result of the budding relationship and joint efforts between Nalsar and International Arbitration and Mediation Center, Hyderabad. The journal primarily endeavors to facilitate the development of scholarship in the field of arbitration and alternative dispute resolution. In furtherance of the same, the journal aims to provide a robust platform for legal minds in all over the country to showcase their critical thinking and analytical abilities in order to positively contribute to the emergent discourse surrounding arbitration and alternative dispute resolution. It is a platform that will provide scholars, researchers, and students alike with the opportunity to share their insights, challenge existing paradigm, and contribute to the ever-expanding tapestry of human knowledge. As you flip through the pages of the journal, you'll encounter the collective wisdom of experts, practitioners, and academicians who have devoted their careers to the pursuit of fair and equitable resolutions. The articles within these covers will not only serve as a source of knowledge, but will also inspire dialogue and collaborations among professionals, academicians, and students. So this journal is a part of Memorandum of Understanding between Nalsar and International Arbitration and Mediation Center. So the process of bringing Nalsar IAMC Areas Journal to the life has been a collaborative effort. I would like to express my deepest gratitude to all those who have contributed tirelessly to make this vision a reality. I would like to take an opportunity to thank our Vice Chancellor, sir, for agreeing and supporting the journal since inception. I would also like to thank Tariq Khan, sir, for his constant support and guidance to the journal. We are very grateful to Honorable Justice Mr. Ashutosh Kumar for being kind in writing forward for our journal. I'd like to thank members of Advisory Board, Peer Review Board for their support. I would like to thank Eastern Book Company for publishing our journal.
Last but not the least, I'm grateful to the editorial team, our editors, Diksha in absentia, and Sahil Agarwal present here, associate editors, Mahika, Tanvi, Mayank, Sikhar, and Nishka, our assistant editors, Masad Khan and Ananya, and our technical editor, Navneet Menon, who has played a significant role in shaping this journal and making this a great success. Your dedication has not gone unnoticed, and I am indebted to you for your valuable contribution. Can you please get a big round of applause for our editorial team? As we stand at the threshold of this exciting venture, let us not forget the responsibility that comes with it. Nalsar IAMC Area Journal has the potential to influence and shape the discourse in the field of alternative dispute resolution. And it is our duty to uphold the highest standards of academic rigor and integrity. Let us use this platform to not only disseminate knowledge, but also to inspire future generations of scholars, researchers, and students. In conclusion, I am filled with anticipation for the journey that lies ahead. Nalsar IAMC Areas Journal is not just a publication, it is a community, a forum, and a catalyst for intellectual growth. Together, let us embark on this voyage of discovery, collaboration, and enlightenment. Thank you all for being a part of this momentous occasion, and I look forward to witnessing the incredible contributions that will undoubtedly emerge from the pages of Nalsar IIMC Areas Journal. Please do not forget to take a copy of the journal while leaving the room. And now I would request Tariq Khan sir to please release the journal. Could you please put the chair? Yes. Ekta ma'am and Vikram sir, Anirban sir, please. दे दो इनका नहीं खुला. Yeah, thank you so much. Thank you so much. Thank you so much, sir, for this wonderful release of Nalsar IAMC Areas Journal. Now I would request VC sir now I would request Tariq sir to say a few words about this journal and about this launch, about this competition.
Honorable Justice Koshi, Honorable Vice Chancellor, Chitra, Ekta, Vikram sir, Anirban sir, a lot of my friends in the front row, our collaborator Cam, Nalsar, the teams that performed today, and all my dear friends. I'll not take much time because I know, everybody is waiting for the result, but this journal has only been possible because of the Vice Chancellor and the editorial board, and very grateful to SCC and the team that worked behind it and all the authors who have worked on this, the advisory board. May I request you all to give a round of applause for VC sir to initiate this. Because I must say, the day VC sir had joined Nalsar, that's when the MOU took place, the same day. And I think it's been a year now. I think we did it on the last NMT. Just one more thing to the teams who performed today. I was the judge in the finals. I think you all have done an excellent job. And it's so heartening to see that the students already in your law school, I was not very acquainted with arbitration and mediation till 5th year. And I learned all of this once I entered the field. But you all are already experts and you understand the process. So it's really nice to see more of these mediation and arbitration events happening. And like Sir, Honorable Justice Koshi rightly said, it's not a competition, it's about collaboration. So none of you is going to lose today. And sometimes it's just destiny. So
whether you lose or you win, I mean, I would never call it losing, but frankly, you're just getting better. You're getting to meet the best in the industry on mediation. We have Chitra, we have Ekta, Vikram sir, and all the other seniors who are here, you can actually meet them. This is a great opportunity for you. So don't look at it as losing. And I wish you all the best and good luck. Thank you very much.
So now I would hand over to the convener of ADA Society.
I think without any further ado, the teams are much awaiting the results. So I'll request our tab master, Yash, to please step forward and announce the results for the tournament.
Hi, everyone. So the much awaited times come here, and I'm here with ex-Candida and other team members to announce the results for the NMT 3.0. So the first award which we are going to give is for the best negotiation strategy in the prelim rounds. I'd like to request Chitra ma'am to come forward for presenting the award. And this award goes to MS Ramaiah College of Law, Yash Alva, and the team. I would like to request Chitra ma'am to present the award for Best Mediation Strategy Preliminary Round. And the award goes to Nehal Pendam from National Law University, Mumbai. Now, I would like to request Ekta ma'am to kindly come forward for giving the best team for the prelims round. And the award goes to the team from NLS Bangalore, consisting of Yash, Siddharth, and Rohan. Now, I would like to request Anirban sir to kindly present the award for the Spirit of the Tournament Award. And this award goes to Christ University, the team consisting of Atharv Nandita and Yash. Atharv Nandita and Yash. Right. Now, I would like to request Tariq sir to kindly come forward for presenting the award for second runner-up mediator. And the award goes to Mishi Bora from NLU Jodhpur. I'd like to request Tariq sir again to present the award for best negotiation, second runner-up negotiation segment. And the award goes to West Bengal National University of Judicial Sciences. The team consisting of Priyansh and Kartavya. Okay. Now I would like to request ML Joseph sir to kindly come forward and present the award for runner-up negotiation and mediation segment. First, coming to the mediation segment. The runner-up mediation segment award goes to Anshuman Yadav. Yes, IPO. Okay. I would like to request ML Joseph sir again to present the award for runner-up negotiation segment. And the award goes to RG Annual Patiala team consisting of Ekam Jot and Devesh are the winners. Mediation segment. Yes. Now, I would like to request Honorable Justice Koshi to present the award for the best negotiation and mediation category. And I would like to request Vaishnavi from our TAB team to announce the results for the mediation segment.
The best mediator goes to Sana Soneja from Dr. Ram Manohar Lohia University, Lucknow, team 410. And the award for the best negotiating pair goes to Team 9 from NLU Jodhpur, Devesh Pratap Maul and Riddhi Pandey. I request Justice Koshi to present the awards.
On behalf of the TAB team, I would like to thank Skandita, Vaishnavi, Sumedha, and Sparsh Khosla, who assisted us in successfully conducting this tournament. And I would like to thank the organizing committee as well. Now over to Yash.
Thank you so much to the TAB team for ensuring that we run the competition smoothly. We will also like to thank our semi-final judges present in this room today towards ensuring that the rounds run smoothly and we can decide the best negotiating and the mediating pairs. Can I please request Vice Chancellor sir to please step forward and present a memento to Mr. Jaideep Kodali, who was a judge for the semi-final rounds. Please, sir. Thank you, sir. Can I please request Prastha sir to please step forward and collect mementos from Vice Chancellor sir? Can we please request Mr. Palas Tang to please step forward and collect his mementos from VC sir? Thank you. Thank you so much, sir. Can we please request VC sir to present a token of gratitude to Justice Sam Koshi for Justice Sam. Can we please request VC sir to present memento to Chitra ma'am? Thank you, sir. Can I please request Ekta ma'am to please step forward and collect mementos from VC sir? Can I please request Emil sir to please step forward and collect his mementos? Thank you, sir. Can I please request Professor Rendert Ban to please step forward and collect his mementos from VC sir? Can I please request Tariq sir to please step forward and collect his memento from VC sir? And we also thank Vikram sir for coming to our campus. Can I please request VC sir to present a memento to Vikram sir? Thank you so much. Thanks to the participants and the judges. Can I please request VC sir to take the mic and share a few words and present vote of thanks to everyone?
But vote of thanks you are present.
Sir, you speak.
Okay. That was wonderful to hear Justice Sam Koshi, sir. I think he underscored the importance and significance of mediation. When we were the students, and I just practiced as 3 years as a trial court lawyer, 85 to 88, in a commercial capital of Andhra Pradesh, that's undivided Andhra Pradesh, Vijayawada. Wonderful. My senior always used to say, behind the dockets are the human beings. They cry, they smile. So that's healing what sir has said. So you must look at them. We can't, maybe sometimes we may provide justice, sometimes we may not be unsuccessful in providing the justice. And also, as many people, when they speak about access to justice, they look at community dispute resolution is a third wave of access to justice. And with the Mediation Act and with the amendment to the Consumer Protection Act 2019, where a new chapter is added to mediation, mediation is really emerging as an important, what do you call as a lawyering method and technique. So happy to see all of you meet and interact. I don't want to take much time. 2 thoughts. First, this must inspire all of you to come to legal practice. Even if you're unable to enter into the mainstream legal profession, wherever you are, law firm, company, wherever you go, remember, mediation or conflict prevention, healing should be your important mantra. Second is, just Koshi sir already has said, participation is enough. You may win, you may lose. That's the spirit. That's what we call as win-win situation. All the best, keep in touch, and we hope to see you in future again. Thank you.
Thank you so much, sir, for your kind words. Since we are reaching towards the end of this ceremony, I just wanted to thank each and every stakeholders who has helped us immensely throughout the preparation for this competition. We wanted to thank VC sir, Registrar ma'am, for helping us at each and every stage, all the faculty members, our respected sponsors, all the judges, all our honorable alumni who have come down from various places to help us organize this event. I wanted to extend a special thanks to my organizing committee, to all the volunteers, to all the support staff, our guards, our mess workers, our social media teams who have helped us to ensure that this tournament is a resounding success and we uphold the high benchmark which was set by my seniors. They say that good things don't come to an end. They just take a pause till the next time. We hope to see you again next year. Thank you so much. Signing off. The teams can collect their participation certificates from the desk. So, yeah, Risha.